Good morning, Mr. Greenie.
Good morning, sir. As you know, first today we will hear the opening statement on behalf of those represented by John McBurney Solicitors, which will be delivered by Mr. Kane.
Good morning, Mr. Kane.
Good morning, sir. This opening statement is made on behalf of the bereaved families and survivor corps participants represented by John McBurney Solicitors. We represent the following corps participants whose loved ones were murdered by the real IRA. Edwin, known as Eddie Cartwright, and Stephen Cartwright, in respect of Deborah Ann Cartwright. Mandy Walker and Mark Hawkes, in respect of Olive Hawkes. Helen Hughes and Richard Hughes, in respect of Julia Hughes. Kevin Skelton, Tracy Skelton, Paula Huntley, Shauna Murphy, and Roy Skelton, in respect of Philomena Skelton. Gerald McFarland and Gerald McFarland, in respect of Samantha McFarland. Marion Radford, Claire Hayes, Paul Radford, Elaine O'Reilly, Carol Radford, Lynn Mullen, and Heather Lagan Radford, in respect of Alan Radford, and Anne Wilson, Denise Kerrigan, Gary Wilson, and Colin Wilson, in respect of Lorraine Wilson. I also appear on behalf of the following corps participants who survived but were injured by the real IRA on that occasion. Lorraine Anderson, Ray Campion, Wendy Graham, Rosemary Ingram, Stephen McKervey, Alan Palmer, Jim Sharkey, and Robert Waltz. Before starting this opening statement, sir, it would be remiss of me not to acknowledge and refer to the commemorative hearings. Any comment elaborating on these would do those days a disservice. I say only that the tsunami of human emotion on those days overwhelmed all those present in the room and beyond. The width and depth of human loss, pain and suffering was overcome only by the courage and strength of those who gave their evidence, both orally and in written form. On behalf of those we represent, could I thank you, sir, and all your inquiry team, staff and support workers. In respect of our own clients, we are grateful for the invaluable assistance from the South East Fermanagh Foundation, whom we know as SEF. It is our privilege to represent a number of bereaved families and injured survivors whose names I have placed on record both this morning and at the initial hearing. That privilege translates into an awesome responsibility to assist both you and the inquiry and to deliver this opening statement on their behalf. You have asked us to focus on areas of particular concern and interest for those whom we represent. We welcome that invitation and will identify those issues. In return, we invite you, sir, the inquiry, to give special attention to them as your work progresses. Preventability is the question that the inquiry must explore. While it's not explicitly stated in the terms of reference, our collective aim and your foremost objective must be to establish the entire truth relating to all relevant issues prior to the 15th of August, 1998. In this task, the inquiry must be guided by principles of transparency, openness, diligence, fairness, candour, and cooperation, all of which are laudable and achievable aspirations in the discharge of the public duty of this inquiry. Our client's key principles were outlined by myself last July. In summary, I repeat those views. First, it is important that we always keep in focus that it was Republican terrorists under the name Real IRA who planned and planted the Omagh bomb. And they alone are responsible for the loss and hurt caused by it. Indeed, on hearing the accounts of so many at the commemorative hearings, it beggars all belief as to what else was intended other than murderous carnage by leaving a bomb in a peaceful town's main street on a busy, sunny Saturday afternoon, where so many innocent women, children, and men were likely to be. The preventability of the murders and injuries was at all times within the absolute control of the Real IRA. Secondly, our clients do not wish to include in any consideration of preventability those members of the RUC who, on the day at the scene, followed orders and used their initiative to try and make safe the area of the bomb, working as they were with false information from the bombers. Those same members of the RUC, as we have heard, valiantly fought at the scene to save lives and to help the injured, as did many others in rescuing and providing medical care. Thirdly, our clients are of the clear belief that whatever aspects of preventability may lie at the door of the UK state authorities, blame, to a greater or lesser extent, rests with the state authorities in the Republic of Ireland. Our clients again renew their call for a parallel inquiry to be immediately established by the Government of the Republic of Ireland, a call that they should not be required to repeat. Fourthly, our clients remain greatly disappointed at the lack of any commitment on the part of the authorities in the Republic of Ireland to meaningfully assist this inquiry. And they regard the Memorandum of Understanding agreed with the Minister of Justice of the Government of the Republic of Ireland as wholly unsatisfactory in that regard. Our clients wish to use this inquiry to heap shame on the Government of the Republic of Ireland for their failures. They consider that there is a moral, human, and legal imperative on the Government of the Republic of Ireland to establish a parallel inquiry into the deaths of people who were their own citizens, visitors to their country, and those who would have been entitled to Irish citizenship under their laws. As a country with a professed European inclination, it is extremely regrettable that the Republic of Ireland continues to be in breach of Article 2 of the European Convention on Human Rights in failing to ensure that there has ever been any effective investigation into the death of the people to whom they owe that duty. There are preventability issues which clearly arise from the territorial origin of the Omagh bomb and the cowardly refuge which its perpetrators enjoyed within the boundaries of the Republic of Ireland. With respect to the work of the inquiry, we do not underestimate the huge challenge that it faces when, unlike some other inquiries which have more quickly succeeded the events which they were examining, your task is to undertake an historical investigation of facts, matters and circumstances in the period prior to the 15th of August 1998. You face the task of exploring policing, security and intelligence policies, practices, processes and procedures within a country fighting against ongoing terrorism. Resources, technology, information storage and analysis, cultural attitudes and political dynamics have all changed so much since the events of 9/11 forever changed how the world viewed and dealt with terrorism. Due to the considerable passage of time, there will inevitably be evidential hurdles for the inquiry to overcome, in particular in relation to document retrieval, deceased witnesses, and memories which have faded. However, the John McBurney core participants caution that history must not be rewritten. They hope that the inquiry will appreciate the grim reality of that particular time in history when Republican terrorists continued to operate against a newly evolving political backdrop. If I could turn then to areas of particular interest and concern. Could I say that there will be repetition of some matters by others, so I will refer to those only in passing before addressing certain particular issues of concern raised by those whom we represent. Some general areas of concern will fall to be considered within the upcoming evidence chapters. Chapter 3, for instance, the bombing of Omagh, which will involve establishing the sequence of events leading to the bombing, and then Chapter 4, which will deal with previous incidents. Can I say we welcome the relevant aspects of the recent ruling made by you on suspects in this regard. There will be some overlap with the subsequent chapter, Chapter 7, concerning intelligence relating to the Omagh bomb, but we can now highlight some questions in preparation for the initial evidence chapters. They include what was done to establish a link between any of the incidents that occurred during the 18 months prior to the Omagh bombing. Were there policing, security or intelligence failures in properly recognising any such links between those incidents? Did those failures contribute to the situation where the potential for prevention of the Omagh bomb was diminished or removed? What was the impact of political developments on the investigation of those 31 incidents? Did political events or influences act as a brake on the investigation and detection of those incidents and the methods used for those purposes? Further, did that have a negative knock-on effect upon the preventability of the Omagh bomb? Were the steps and processes of downgrading border security a consequence of political influence and considerations? More broadly, now is perhaps not the time to examine in any detail all the many issues which have emerged over time and give our clients cause for concern, but it is perhaps appropriate at this stage to highlight two by way of example. And they are, first, some of our clients have grave concern about the missing threat book. Their calls for an explanation of the disappearance of such an important document cannot continue to go unanswered. Secondly, some of our clients have deep-seated concerns as to why British Army personnel were not deployed in the Omagh area either before or on the day of or after the Omagh bombing. They want to know whether this departure from normal security measures was deliberate. I'm now going to deal with the Republic of Ireland and the issue of preventability. And that is one of our clients' main areas of significant concern, to which I've already referred. And that is the responsibility of the government of the Republic of Ireland and their state authorities to have prevented the Omagh bomb. Kevin Skelton, whose wife Mina was murdered, gave evidence to the inquiry during the commemorative hearings, and he reflected on this particular area of concern in his own perceptive and succinct Tyrone vernacular when he said, and I quote, "But the British government, I don't know. Sorry, but the Irish government, I don't know. I don't see them playing ball with this inquiry. And if they don't, then it's dead in the water, because at the end of the day, the bomb was made in the south. The people who built the bomb were from the south. The car was stolen in the south. The car was driven from the south and planted in Omagh. And them boys drive back home again. And there's some of them still walking the streets. That is how the families and the injured survivors whom we represent feel. That is a fundamental concern. With the utmost respect to this inquiry, our clients have likened the work of the inquiry to the role of an MOT test centre, where a vehicle has been taken for inspection. To their disbelief, our clients, the customer, are told that only the engine can be inspected. All that exists beyond the engine, including the body, the suspension, the brakes, and the contents of the boot, cannot be examined. Such an MOT would clearly be unfit for purpose. This inquiry can only examine the parts of the car made in the UK, as it were, the preventability. It cannot examine the rest of the car, where the terrorists sat, or the boot area where the deadly bomb was hidden. If this inquiry could examine the whole car, then it would also be able to identify any preventability issues that fall on the Republic of Ireland state authorities, and all the faults and defects in the vehicle could be identified. The John McBurney Corps participants are very anxious to press the inquiry, to spend considerable time and effort dealing with paragraph 2I of the terms of reference. Paragraph 2I states that the inquiry will investigate, and I quote, any other matters which are relevant to whether the Omagh bombing on the 15th of August 1998 could have been prevented by UK state authorities. To the extent it is relevant to the issue of preventability by UK state authorities, this may include information sharing and investigations with and by state authorities in the Republic of Ireland. End of that quotation. The opening statement's protocol in paragraph 18 acknowledges that, and I quote, opportunities at this stage for submissions on the detail of the evidence, unquote, by ourselves are circumscribed by the limited material that has been made available to date. However, there are, from even the most preliminary perusal of some of the documentation that has been made available by the inquiry, issues which only intensify the concerns which I have indicated. I take only a small number of examples and will make some brief observations. The report of the Smith inquiry, dated the 29th of November 2013. The Smith inquiry was quite prepared to make a finding that, and I quote, there was a failure on the part of the RUC to put all relevant information in its possession before An Garda Síochána, when requested by Deputy Commissioner Conroy to do so. The failure in this respect relates to the 1985 intelligence in its possession, unquote. On the 6th of December 2013, Mr. Michael Gallagher swore an affidavit in the judicial review proceedings in which he refers, in paragraph 14 of that affidavit, to an assurance given to the bereaved families by the Prime Minister of the Republic of Ireland, Bertie Ahern, that, quotation, no stone would be left unturned, unquote. However, that is a promise which has significance only for the ignoring and disregarding of it, which has taken place over the almost 27 years which have passed since the Omagh bombing. The Bridger report, which was published in June 2012, states clearly on page 11 that, quotation, public confidence can go some way to being restored by both the British and Irish governments showing that they are willing to do their utmost to have perceived failures fully investigated and dealt with. Without going into detail, a plethora of issues arise from reports over the years which warrant careful scrutiny by your inquiry. They include the activities of Kevin Fulton in the Republic of Ireland, the activities of David Rupert in the Republic of Ireland, the extent to which knowledge of those individuals was in the possession of or attributable to the state authorities of the Republic of Ireland, the credibility of the information being supplied by Garda Detective Sergeant John White, the role of Dermot Jennings, Assistant Commissioner of the An Garda Síochána, with responsibility for security and intelligence. A clear allegation by Enda Kenny, the former Taoiseach of the Republic of Ireland, as to, and more generally, the inadequate nature of the Nally report and its investigations, the interactions between An Garda Síochána and RUC senior officers, including intelligence sharing, and the issue of mobile phones, tracking, and the security services. Our clients wish for the inquiry in considering any material relating to interactions with authorities in the Republic of Ireland to explore any failures on the part of those authorities which are explicitly or implicitly demonstrated by such material. And Kenny also stated during a debate in the Dáil on the 20th of February 2004, prior to his election, and I quote, "You will get your truth. You will get your truth, and so will Ireland." Sir, I have the authority of those I represent to say that they are sick and tired of platitudes, false assurances, broken promises, and grand but empty words from the state authorities of the Republic of Ireland. Their resolute refusal to institute a parallel inquiry and their ongoing failure to provide real and meaningful cooperation with this inquiry speaks far louder than their words. All of this leads to consideration of the Memorandum of Understanding dated the 15th of April 2025 between the inquiry and the Minister of Justice of the Government of Ireland on, entitled Matters Relating to Disclosure of Materials. Mr. Justice Horner, in the judicial review proceedings brought by Michael Gallagher, stated in paragraph 310 that an investigation, and I quote, will necessarily involve the scrutiny of both open and closed material obtained on both sides of the border. It is not within my power to order any type of investigation to take place in the Republic of Ireland, but there is a real advantage in an Article 2 compliant investigation proceeding in the Republic of Ireland simultaneously with one in Northern Ireland. Unquote. It is against the background of defiance to such a request and its continuance by successive governments of the Republic of Ireland in ignoring the pain and plight of the Omagh families and survivors that has led to their signature on the Memorandum of Understanding, in a cynical effort to appear to be assisting and cooperating and to alleviate the pressure of the commencement of this inquiry on themselves. They grasped this opportunity of a fig leaf. Any analysis of the Memorandum of Understanding must have the starting point that this inquiry, by its terms of reference, can only look at, as I quote, whether the Omagh bombing could have been prevented by UK state authorities, unquote. This limitation is then compounded by a further limitation: the mere commitment of the Government of the Republic of Ireland to disclose what it considers to be, quote, potentially relevant materials, unquote. These two limitations make the memorandum redundant. First, because the assessment of relevance is in the power of the Republic of Ireland. Secondly, because it only relates to relevance concerning preventability by the UK state authorities. This is an unacceptable yet significant escape clause for the Republic of Ireland. Under the memorandum, the Republic of Ireland's state authorities, and therefore any information that reflects badly on them, could be determined by them to be irrelevant. The recitals to the Memorandum of Understanding state that the Government of Ireland's provision of assistance to the inquiry is solely within the grant of the Government of Ireland. This voluntary statement of participation by the Government of the Republic of Ireland lacks any degree of real commitment and does nothing to give our clients any degree of confidence in it. Similarly, the memorandum relates only to documentation. There is no power to compel the attendance of witnesses. To take an example, in the recent corporate witness statement provided on behalf of the Police Service of Northern Ireland, to which I'll return, it is stated in paragraph 384 that Assistant Commissioner Dermot Jennings, who was in the Security and Intelligence section of the An Garda Síochána, informed the Nally Group that he was in frequent contact with the RUC about operational matters in and around the period of the Omagh bombing. Details as to how frequent this contact was, the nature of the contact, the records of such contact, the personnel involved, and whether the phrase in and around the period of the Omagh bombing primarily means after the event, among many other details, would all be the sort of ideal sort of inquiry to be made seeking documentary disclosure and cross-examination of witnesses, such as Mr. Jennings, as part of the parallel inquiry if it were to be held in the Republic of Ireland. Such necessary inquisitorial demands cannot be satisfied by the arrangements established under the Memorandum of Understanding. Even as to documents, the memorandum entitles the authorities in the Republic of Ireland to act and react only to specific disclosure requests. There's no commitment to carrying out either any general, full or comprehensive search for or any analysis of documents which may be within the possession of its state authorities and of which this inquiry might have no knowledge. In fact, under the Memorandum of Understanding, the authorities in the Republic of Ireland may form the opinion that it is best, in its own interest, not to look for anything at all, unless specifically asked to by this inquiry. To add insult to injury, even if inadvertently the existence of a relevant document is made known to this inquiry and such a document is duly requested, the unilateral power of redaction remains with the Government of the Republic of Ireland. This will be applied to all documents as the state authorities of the Republic of Ireland see fit, before such documents even cross the border to this inquiry. Having regard to the previous experience of the King's Mill families at their inquest into murders on purely sectarian grounds by Republican terrorists operating from the Republic of Ireland, our clients have no confidence whatsoever in the workings of Section 3 of the Criminal Justice International Cooperation Act 2019. Perhaps one of the most telling statements ever to have been made by the An Garda Síochána was that contained in their written submissions to the Smithic inquiry. Under paragraph 17 of their written submission, they stated, quote, "The RUC and northern authorities were not obliged by the tribunal to comply with orders for discovery. As such, they were able to decide themselves what they would disclose and what they could conceal." End of quote. Such an attitude and accusation does nothing to suggest that any better self-serving approach would prevail in the provision of assistance to this inquiry by those authorities in the Republic of Ireland who may have this in mind. Finally, in this regard, it may be of interest that the evidence of the Police Service of Northern Ireland in the recent corporate witness statement provided on its behalf is that the retired former senior officers who assisted with the statement have explained that the realities of the time were that, and I quote, "the provision of information by the An Garda Síochána to the RUC of the type which would allow for preemptive operational action by the RUC against subversives was very rare." Unquote. If I could now deal with the political context. The other significant area of concern for the families and injured whom we represent is the political background in the period leading up to the Omagh bombing. This is part of the inquiry's investigation and will be covered in Chapter 5 under the heading "The Peace Process and Security and Normalisation." At this juncture, our clients have one basic question to pose to this inquiry. Could it be that the peace process, the Belfast Good Friday Agreement, and the political dynamics thereafter led to circumstances in which the Omagh bombing was not preventable? This is a vast area in relation to which our clients require the most intense and detailed investigation. Were the political directions emanating from the governments of both the United Kingdom and the Republic of Ireland such that interference with security measures, installations, surveillance techniques, mobilisation and deployment of manpower and other resources all led to a situation whereby preventability of the Omagh bombing became an impossibility to a greater or lesser degree? We wish to know to what extent there was diminishing activity against Republican terrorists, lest such activity could disclose the involvement of well-known individuals in the Provisional IRA and Sinn Féin, all of which would have been very harmful to the ongoing peace process. It may be of no small significance that the Intelligence and Security Committee, in their annual report of 1997-1998, reporting on the 31st of July 1998, just days before the Omagh bombing, stated at paragraph 16, and I quote, "For the security service, the renewed ceasefires in Northern Ireland led directly to a drop of over 5% in the service allocation of resources to Irish and domestic counter-terrorism work, from 24.8% to an anticipated 19.5% during the course of the year. Despite the ceasefire and the Good Friday Agreement, there are clearly still elements in Northern Ireland who are intent on using terrorism to further their political aims." Unquote. I will turn shortly to give a brief and immediate response to the opening statements with which we have been provided from State Corps participants. However, at this stage, I am compelled to highlight a most astonishing, shocking, and incredible revelation. This is found in the corporate witness statement provided on behalf of the PSNI. In the course of that statement, reference is made to what are called security policy meetings, attended by the Secretary of State and other senior representatives, including the Chief Constable, the General Officer Commanding of the Army, the DCI being the Director and Coordinator of Intelligence within the Security Service, and the Permanent Secretary of the Northern Ireland Office. At paragraph 251 of the witness statement, in response to the inquiry's request for copies of the agenda, briefing paper and minutes of such meetings, the PSNI states, quote, "The PSNI has located agendas, briefings and minutes for SPMs for 1996, but none for 1997 and 1998, unquote. The reality of the above statement is as staggering as it is incredible. It is hard to imagine a more high-level set of meetings to discuss security and intelligence considerations and policy touching upon the lives of the citizens in Northern Ireland in the years 1997 and 1998, and yet no record of those meetings has to date been located. Such a revelation only serves to heighten the suspicions and fears of the Omagh families and survivors that there are views to be hidden and information to remain undisclosed at the highest possible level for deep-seated but hugely embarrassing and difficult political reasons. Then, dealing briefly with the disclosure and corporate opening statements, evidence chapters 3 to 7 will all require an analysis of policing, security and intelligence information. The families and injured we represent have come to this inquiry, some with degrees of reluctance, given the passage of time and the lack of any investigation which is adequate to date by the state authorities, either in the UK or in the Republic of Ireland. Within the context of the present inquiry, an imperative must be that there will be full and open disclosure of material. A general comment can be made that there is need for as much open material as possible to be disclosed to the bereaved families and injured survivors as core participants. That should be the starting point and should not be deviated from unless there is clear and compelling reason established with evidence for material to become closed. We strongly urge you, sir, and this inquiry, when applying the relevant test, to take a robust approach in support of the interests of the bereaved families and injured survivors, and to disclose material or parts of material whenever it is possible to do so. Finely balanced judgments should fall in their favour. Dealing then with the PSNI corporate witness statements. It was therefore with considerable dismay that we read the corporate witness statement provided on behalf of the PSNI and the addendum thereto. These documents were disclosed by the inquiry 2 weeks ago. I've already highlighted the appalling absence of the documents relating to the security policy meetings for the years 1997 and 1998. That position, however, is made all the more difficult to comprehend when, in the addendum witness statement at paragraph 30, a fallback position is a comment smacking of desperation. That any reports conveyed during higher level meetings, such as the security policy meetings, quotation, may or may not have been written, unquote. However, that has then to be compared against a further effort in desperation, where, at paragraph 79 of the addendum statement, it is said that it cannot even be definitively stated, quote, how often such meetings normally took place, unquote. These are meetings between the highest level of security officials and politicians within Northern Ireland. Such responses to this inquiry are astonishing and do nothing to inspire confidence. This inquiry must pursue these matters with all possible diligence, determination, and strength. It is wholly unacceptable that the mantra of hear no evil, see no evil, now includes write no evil and keep no evil. I will restrain myself, sir, from alluding to the images which usually accompany such phrases. All I will say is that the families and the injured survivors deserve better. They deserve respect. This inquiry also deserves better, and it deserves respect. It is also of deep concern to our clients that the corporate witness statements provided on behalf of the Police Service of Northern Ireland now reveal that not only have the most important documentary records of meetings in 1997 and 1998 not been located, but additionally, crucial intelligence documents, some of which have political and security policy development aspects, also cannot be located. In total, 8 categories of documents solely relating to Northern Ireland and the United Kingdom state authorities cannot be located, and 3 additional categories of documentation relating to the RUC and An Garda Síochána cannot be located. Additionally, and regrettably, it appears that this malaise of being unable to locate important documents extends to documents relating to important regular cross-border meetings in the critical period. They are, first, monthly meetings between the Assistant Commissioner for Crime and Security in the An Garda Síochána and the head of special branch of the RUC and the Intelligence Management Group. In the corporate statement addendum, it is said in parentheses, as if to portray it as an acceptable aside, that, I quote, the PSNI has not been able to locate the minutes, unquote, of any of these meetings. Secondly, regular cross-border senior officer meetings, chaired jointly by the Deputy Chief Constable of the RUC and the Deputy Commissioner of the An Garda Síochána. In paragraph 39b of the addendum statement, it is said again in parentheses that the PSNI has not been able to locate the minutes of any of these meetings. And then thirdly, meetings between the RUC and any other organisations within the Republic of Ireland. At paragraph 394 of the main corporate statement provided on behalf of the police, it is stated, that I quote, the PSNI has not located any record of the RUC engaging with any other organisations within the Republic of Ireland with responsibility for gathering intelligence about the activities of those engaged in acts of terrorism other than An Garda Síochána. End of quote. Mr. Chairman, may I just pause to say this without further elaboration at this point. A critical question to which this inquiry may wish to pay particular attention is any contact with the Army Intelligence Services of the Republic of Ireland. Such a profoundly serious state of affairs as to this asserted absence of documents represents to ourselves a disastrous commencement of the substantive work of this inquiry, and leaves our clients with a distinct lack of confidence and assurance in the cooperation of the state core participants, in particular the PSNI. For ease of reference, in addition to the professed absence of any documents from security policy meetings, to which I've already referred, there are 7 other categories of documents which also are stated as being unable to be located. We have specifically itemised those 7 categories in our written open statement, which is available. However, it is noted in passing, in paragraph 264 of the main corporate statement provided on behalf of the police service, that certain documentation relating to the minutes of lesser groups was classified as, I quote, secret, unquote, and, I quote, kept either in Special Branch headquarters or in the Chief Constable's office, unquote. All of this is particularly regrettable in light of the criticism of the PSNI years ago in 2010 by Lord Maclean in the Billy Wright Inquiry Report. He found the reasons given by the PSNI for failing to disclose information to be unconvincing, inconsistent with the evidence, unsatisfactory, and inadequate. He concluded with concern that there may have been, and I quote, deliberate malpractice, unquote, involving the, and again I quote, destruction of audit trails and the concealment of evidence which might have been damaging to the reputation of the RUC, unquote. The question is being understandably asked whether anything has changed, and why are the Omagh families and survivors being potentially subjected to similar treatment? In summary, therefore, at this early stage of the inquiry, these are initial responses which fill the hearts of our clients with considerable disquiet and bode ill for the efficacy of the work of the inquiry, despite its best intentions in the days ahead. And could I say, sir, that we welcome the intensity of scrutiny and effort in relation to documents which have been declared as not able to be located from Mr. Greene in his brief opening yesterday. However, proof of the pudding will be in the eating. We were greatly assisted by the structure of the corporate statements provided on behalf of the PSNI, which included the text of the relevant Rule 9 requests to which a response was being provided. In circumstances where the bereaved family and survivor corps participants have not separately been provided with or had visibility of the Rule 9 requests issued to the state and organisational corps participants and the others who may have documents and evidence to give, we welcome this approach and ask that it be adopted by all who provide Rule 9 responses to this inquiry. Turning then to Sir Ronnie Flanagan's opening statement. Sir Ronnie Flanagan, in his opening statement in paragraph 31, appears to be very concerned about hindsight. He reminds the inquiry of a quotation from Sir Anthony Hidden QC, a rather apt name in the circumstances, and suggests that there is, I quote, a requirement for an inquiry to remind itself of the danger of hindsight, unquote. We would suggest that it is not hindsight itself which is dangerous. Instead, it is any wrong interpretation of what hindsight reveals. However, it would appear that the primary danger for this inquiry might well be not hindsight, but the absence of sight of crucial documentation held by state authorities. The Secretary of State also made an opening statement, and it is disappointing to read a purported summary of the judicial review proceedings in which the decision of Mr. Justice Horner is described at paragraph 18 as having been based on the fact that he, quotations, that's a quotation from the opening statement of the Secretary of State, found that the relatively low bar of plausible argument was made out in relation to 4 of the 10 grounds of challenge, unquote. The John McBurney Court participants consider that the plain insinuation being made is that this inquiry exists only because of a low bar was applied in judicial review proceedings. This wrongly and unfairly minimises the work of the inquiry and the weight of the evidence already available to it. Indeed, it is especially bold for such loaded comments to be made in the context of the Secretary of State core participant group declining your invitation for concessions to be made, given the substantial time which they, and indeed other organisational core participants, have already had to understand and investigate their role in relation to the Omagh bombing. In a similar vein, it is hoped that all restriction orders which may be sought will be limited to such materials as can properly be considered sensitive, whether on national security or on other grounds. However, again, the recent approach of the Secretary of State to the redaction of all names of junior civil servants from otherwise relevant material, on which a ruling has now been given, confirming that the Secretary of State's alleged assessment of relevance was erroneous, did little to reassure the John McBurney Court participants that they will receive the standard of openness, candour and transparency that they can and do expect from state core participants. Finally, dealing with the Police Ombudsman's opening and corporate statement, on the matter of open and closed materials, I wish to mention the approach of the Ombudsman. The inquiry has recently disclosed a corporate witness statement provided on behalf of the Police Ombudsman. That statement is said to be offered in response to Rule 9 requests from the inquiry. The internal headings of the statement make clear that the Rule 9 request had 6 parts. It is therefore difficult to understand and disappointing that the Police Ombudsman considered that the Rule 9 request merited a response in relation to only one of those parts, namely Part A, which concerned general background as to the role and functions of the Police Ombudsman for Northern Ireland generally. The other 5 parts of the Rule 9 request, parts B to F, related to the following important topics: engagement with the Republic of Ireland, knowledge of past attacks, Kevin Fulton, David Rupert, and other agent reporting. Each of those topics received no substantive response. Instead, it was stated, this will be addressed within the closed version of my statement. It seems to our clients difficult to believe that after 26 years, there's nothing that could be said about any of these topics on an open basis. Such an approach serves to exclude the bereaved families and survivor core participants. The inquiry should be cautious to guard against any narrow, lazy, or obstructive approach by state core participants to the disclosure of relevant material, and must ensure that any closed material is minimised. Sir, those are our opening remarks. We wish you well in the task which you are about to embark upon and which you have already carried out considerable work. And we hope that there will be positive outcomes, and we will be here to assist, but also to watch, observe and comment as this inquiry proceeds. Thank you very much.
Thank you, Mr. Keane.
So could we take a short break, please, before we hear from Mr. Southey? Thank you, sir. As I said, we'll now hear from Mr. Southey.
Good morning, Mr. Southey.
Good morning. This opening statement is made on behalf of the following families who lost their loved ones in the Omagh bomb on Saturday, the 15th of August 1998, and whom I and the rest of the Fox Law legal team have the privilege to represent. Michael Gallagher, Patsy Gallagher and Kat Wilkinson, who lost a son and brother, Aidan Gallagher, aged 21. Stanley McComb, Clive McComb and Colleen McComb, who lost a wife and mother, Anne McComb, aged 48. Edith White and Linda White, who lost a husband and father, Fred White, aged 65, and a son and brother, Brian White, aged 27. Michael Monaghan, Patrick Monaghan, Aveen Monaghan, Ailish Monaghan, who lost a wife and a mother, Avril, and a daughter and a sister, Maura Monaghan, mother, Avril, aged 30, the daughter and sister, Maura, aged 20 months, and Avril's unborn twins. Michael Doherty, Bernadette Doherty, Amanda Doherty, Kiva Doherty, Killian Doherty, Aileen Doherty, Lisa Dillon, Garrod Doherty, Ushin Doherty, who lost a son and brother, Oren Doherty, aged 8. John McLaughlin and Patricia McLaughlin, who lost their son, Sean McLaughlin, aged 12. Joe Marlowe, Bridie Marlowe, and Nikki Lucas, who lost a daughter and a sister, Jolene Marlowe, aged 17. Victor Barker, who lost his son, James Barker, aged 12. Bernadette McGrory, Louise McGrory, Colin McGrory, Brian McGrory, who lost a son and father, Brian McGrory, aged 54. Jose Abad Esquivel, Paloma Abad Ramos, and Anna Abad Ramos, who lost a daughter and a sister, Rocio Abad Ramos, aged 23. Nuala McGrath, Conor McGrath, Gavin McGrath, Nolene McGrath, and Cara McGrath, who lost a husband and a father, Sean McGrath, aged 61. Gareth McChrystal and Rosemary Cooney, who lost a mother and a sister, Geraldine Breslin, aged 43. Patrick Grimes and Fergal Grimes, who lost their mother, Mary Grimes, aged 66. Elizabeth Gibson and Caroline Martin, who lost their sister, Esther Gibson, aged 36. This statement is also on behalf of the following survivors who were injured as a result of this atrocity and who, again, I and the rest of the Fox Law legal team have the privilege to represent. Donna Marie McGillian, Gary McGillian, Jamie McGlynn, Michelle McCullough, Suzanne Travis, Mary Christina Kelly, Giles McCourt, Ronan McGrory, Nikki Lucas, Sandy Marcus Smith, and Monica Taggart. At the outset, it must be clearly stated that there is no doubt who is to blame for the bomb. Responsibility for that atrocity rests firmly with the dissident Republican terrorists who planned, resourced and planted this bomb in the knowledge that it had the potential to cause mass destruction and have such devastating consequences as evidenced during the commemorative hearings. Nothing that follows is intended to suggest that responsibility is shared with anyone other than dissident Republican terrorists, or that their guilt is mitigated in some way. As was said during the commemorative hearings by Suzanne Travis on the 13th of February this year, this was a cowardly, wicked act that took away so much. However, without in any way wanting to detract from the unqualified statements I've just made, the guilt, wanting to detract rather in any way from the unqualified statements I've just made about the guilt of dissident Republican terrorists, what I've just said does not mean it is not legitimate and important for questions to be raised about possible failings by the state in relation to protection. In a modern democracy, there will always be, unfortunately, people who seek to disrupt society. Both individuals and society collectively expect the state to protect its citizens from the threat of violence and the risk of harm. That is why the state funds security services such as the police and enacts special powers to enable those services to be effective. The reality is that nobody would have been in Omagh enjoying a beautiful summer day had there not been an expectation of effective state protection. As described during the commemorative hearings, the town was busy, and I distinctly recall the chatter of many of the visitors as they conversed in Spanish. There were children running about, and the town was expecting the procession of the parade in a short time. The sun was shining, and in all, it was ideal for a summer carnival in Omagh. That was the statement of Jamie McGlynn. And that joy, essentially, was joy in the knowledge, essentially, or the belief that there was effective state protection available. Society's expectations of protection are reflected in the recognition of the importance of the right to life found in human rights instruments such as Article 2 of the European Convention on Human Rights. That has been said by the European Court of Human Rights to rank as one of the most fundamental provisions in the Convention, one which in peacetime admits of no derogation under Article 15. It enshrines one of the most basic values of the democratic societies that making up the Council of Europe. A key aspect of that right to life is the duty imposed on states to provide effective protection, such as that found in the judgment of the European Court in Osman. The duty to provide protection is in part made effective by the duty that is imposed on the state to investigate potential breaches of Article 2. That duty gave rise to this inquiry, as is clear from the judgment of Mr. Justice Horner, as he then was. That duty exists in part, as was held by the Supreme Court, or rather the House of Lords in the Amin judgment, because those who have lost their relative may at least have the satisfaction of knowing that lessons learned from this death may save the lives of others. These matters demonstrate that it is legitimate for questions to be raised about whether state agencies took steps that we expect them to take to protect and that law obliges them to take. As Michael Gallagher said to the Northern Ireland Affairs Committee on the 16th of March 2009, we will not remove the blame from those who are responsible, and that is the real IRA. They took responsibility for it. They are the people who created an extremely lethal and dangerous situation in Omagh and expected others to deal with it. Our call for an inquiry is not to shift blame from those who rightly should receive that blame, but to see what went wrong and what should be done to put it right. So what do the families seek? The families wish to put on record, firstly, their gratitude to the inquiry for the dignified and considered manner in which the commemorative hearings were approached and managed. It highlighted the place of the families and survivors at the centre of the process and demonstrates the importance that they should remain the focus of the inquiry at each and every stage. The hearings allowed the families of the deceased to remember their loved ones and conveyed their loss through their pen portraits, and for the survivors to tell their experiences and describe the impact that the bomb has had on their lives. The hearings also provided the first responders with an opportunity to communicate their own experiences of the harrowing situation that they faced and the difficult task they had to undertake. Several themes are clear from the evidence during the commemorative hearings. First, it is clear there is a desire for the inquiry to conduct a thorough and comprehensive review of the circumstances surrounding the Omagh bomb. For example, Paloma Abad Ramos said on the 28th of January, "Learning about the inquiry has filled us with hope, the hope that a lot of the unanswered questions will finally be dealt with in a thorough and robust manner, the hope that all of those who lost loved ones and survived can find out the whole story as to what happened." Second, one reason why it's important there is a thorough and comprehensive review of the circumstances surrounding the Omagh bomb is that the families need to heal. For example, Gareth McChrystal said on the 30th of January, "People in the wider community have questions that remain outstanding and they want answers to, and I sincerely hope they find the answers. I hope I find the answers I'm looking for, and I hope this is a cathartic process for those who involve themselves in it." Similarly, Nicola Marlowe said, "I hope some people get the closure they need to overcome some of the challenges they've faced in the past 26 years." In a real sense, this may be a last opportunity for a cathartic healing process. As Donna Marie McGillian said on the 12th of February, "And I'm not too sure that we can keep doing this. I mean, this is really hard. It's really hard to, you build yourself up in a way where you are, it's never a way, but you build yourself up in a way where you're coping, and then you have to do this again. And I just can't do this again." Thirdly, another reason why the victims seek a thorough and comprehensive review of the circumstances surrounding the bomb is consistent with what I already said about the judgment in Amin. It's a desire, the victims have a desire to prevent repeats of any failures. As Stanley McComb said on the 4th of February, "The inquiry is about making sure that something as barbaric and heinous as the Omagh bomb is not allowed to happen again. It's about learning lessons and standing up for truth and justice." Fourthly, it's clear that an extraordinary level of suffering has resulted from the Omagh bomb. For example, Chair said in responding to the evidence of Fergal Grimes that Mr. Fergal Grimes mentioned the words of the coroner spoken at the inquest into the killings, which took place in the year 2000, when the coroner mentioned that he could not recall any one family suffering such a loss in the history of the Troubles. 26 years later, those words still resonate as a powerful measure of the extent of the cruelty inflicted upon this family. These matters demonstrate why it is so important that the inquiry undertakes its role with rigour, thoroughness, and in a manner that has the confidence of the victims and survivors at its heart. An important aspect of this is that the inquiry does not rule out issues too early. For example, it's important not to rule out issues relating to the warning calls and the response to those calls at this stage for a number of reasons. First, the victims and survivors argue that there is a need for all, or there was a need rather, for all intelligence and information suggesting a threat to be considered by a single body with responsibility for protecting the public. This would have allowed a clear view to be formed of the threat, which may have enabled a more effective response to the warning calls. For example, a recognised code word was used. There was available intelligence that the time between a bomb warning being given and detonation had been shortened by dissident Republicans. There is a need to investigate and assess if this information about a reduced time to respond particularly when combined with other intelligence, should have impacted on the response and evacuation procedures implemented on the day of the bomb. Second, there's a need to investigate what I will describe as differential policing. And what I mean by that is whether the policing of terrorism in Northern Ireland was as effective as that in England. Preparedness for warning calls is an aspect of this. Did England have more effective procedures to respond to bomb threats? Third, the Army had regularly been called upon during bomb alerts as it possessed a range of expertise, including bomb disposal expertise. However, on the 15th of August 1998, they were not deployed into Omagh following warnings being issued. At the commemorative hearings, Kevin Skelton commented that for every bomb scare up to 14th and after the 16th of August 1998, the Army had been brought onto the streets to clear the town. This raises the question of why the Army were not deployed on the day of the bomb, and what was the protocol governing their attendance. The victims and survivors submit that an aspect of preventability is whether the decision not to deploy the Army was or should have been influenced by intelligence and other materials suggesting a threat. I'm going to come to that evidence about intelligence later. Further, in terms of issues that shouldn't be ruled out, although it's accepted that the investigation of the bomb is not directly related to preventability, it potentially needs to be considered for the following reasons, among others. Firstly, it may shed light on issues of preventability. For example, it may shed light on the extent to which there were effective mechanisms to ensure that intelligence was shared. Secondly, it may shed light on the likely approach to the investigation of the prior incidents, such as Banbridge. And finally, it may be relevant to the weight that can be placed on the conclusions of the contemporaneous investigation. In light of the matters above, or the matters I've just outlined, although it's accepted that the terms of reference mean that there are limits to what the inquiry consider, it is the position of the families and survivors who I represent that it's important to the credibility of the inquiry that issues are only ruled out after a review of the evidence demonstrated that it's clear that there is an evidential basis for ruling the issues out. That evidential basis needs to be explained to the victims and survivors. One aspect of rigour that is particularly important to the victims and survivors is the need to investigate with care claims that the inquiry has been provided with full disclosure and full evidence. There is a significant body of material that demonstrates that relevant evidence has been withheld from official investigations in the past. This material includes the interim Canova report, which states, and I quote, "In advance of my evidence to the Northern Ireland Affairs Committee in September 2020, I telephoned a number of my predecessors to inform them that I was giving evidence to and to ask if there was anything they might wish me to pass on to the committee." I'm now about to read out the passage of the Canova report which details what was said during those calls. David Cox, former head of PSNI's Historical Inquiries team, said, "They, meaning PSNI intelligence, always gave me a limited version of the truth. They invariably did not and will not give up information." Lord Stevens, when referring to the security forces, said, "I was misled deliberately. I was criminally instructed from doing my job by the by the RUC and the military, whilst MI5 failed to disclose information." Judge Pomerantz, senior counsel to the Corrie inquiry, said, "We could not compel material being provided. Others controlled what we received and when and how we received it, and the conditions in which we received it. They, meaning MI5, made the entire process uncomfortable. The state viewed itself as above the law." Mary Laverty, senior counsel to Judge Smithick, said, "They, the security force, meaning the security forces, made it incredibly hard. When will they decide they can reveal the information? Moving on from Canova to the Billy Wright report, that states, the evidence which the inquiry has heard from several witnesses and the clear indication in the Alpas report of 2000 of the enormous number of hard copy files which were in existence mean that it's very puzzling that the PSNI has been unable to produce any significant hard copy intelligence records from 1997. Where they are, or if and when they were destroyed, remains a mystery. Finally, the Police Ombudsman report entitled Investigation by Police of the Murder of Mr. Sean Brown on the 12th of May 1997 states, the box file was not available on the 23rd and 24th of May 2001 and was formally declared missing on the 26th of July 2002. The inability of the police service of Northern Ireland to produce this document had massive consequences for this investigation. The experience and learning from these investigations and reports demonstrates a need for the inquiry to probe with care material provided to it to ensure that it is complete and accurate. At this early stage of the inquiry, it's concerning that it's already being indicated on behalf of the Police Service of Northern Ireland that potentially relevant documents connected to the intelligence community, some from the highest level, cannot be located. These include any reports provided by the Royal Ulster Constabulary to the Secretary of State for Northern Ireland, agendas and briefings and minutes of the security policy meetings held in 1997 and 1998, despite 1996 being available. Relevant Northern Ireland intelligence reports, which have been created by the assessment group, part of the security service. There are further examples of documents that appear to be missing in the written submissions submitted on behalf of Fox Law. It's accepted there has never been a successful conviction of anyone in relation to the Omagh bomb. However, in the time since the bomb, there have been related criminal trials, civil trials, investigative reports, a judicial review that resulted in this inquiry. Therefore, given this continual review and assessment, there should be an expectation, and there is an expectation on the part of victims and survivors, that all relevant material is available, and that any reason proffered for a document being lost or destroyed is fully investigated. The documents I've already identified are all ones that one might expect to have been retained in light of the investigations and reviews. The victims and survivors who I represent also submit that there should be no delay in the provision of the materials from the state core participants. A significant period of time has already passed since proceedings were issued in 2013, challenging the decision of the then Secretary of State for Northern Ireland not to hold a public inquiry. And it's been 4 years since that decision was overturned. It is the position of the victims and survivors who I represent that state bodies have been on notice since at least 2021 that all relevant documentation would be sought for the purposes of an Article 2 compliant investigation. The submissions that I've just made are not intended to cast doubt on the good faith of any current state official. The victims and survivors appreciate the commitments of the state core participants to this inquiry. What the submissions are, however, intended to demonstrate is why the victims and survivors I represent are concerned that a culture of non-cooperation with investigations may need to be challenged, and why claims that material cannot be discovered must be examined with care. Can I then turn to the issue of the timing of this opening statement? It is regretted that state court participants have concluded they are unable to make any concessions at this stage. In particular, the Secretary of State has been alert to the issues raised since 2013 at the latest in light of the judicial review proceedings. The duty of candour in the judicial review proceedings should have required a full review of the relevant documentation. It's also regretted that there's been little engagement by the state court participants with the substantive issues raised by the inquiry. This means that this opening statement is made without knowledge of the state's position. Further, at the time this statement is being made, full disclosure and oral evidence is still to be provided. All of these matters have several consequences. First, in the same way that the victims and survivors expect and believe that the inquiry should not prejudge matters, the victims and survivors do not want to that I represent do not want to prejudge matters. Second, and in light of the footpoint I just made, this opening statement will identify themes and issues that are important to the victims and survivors I represent. However, these submissions cannot be complete. Issues may arise as further evidence is disclosed. It's noted that the inquiry may provide the opportunity for opening statements at the commencement at some or all of the various chapters. This approach is welcomed given the limited disclosure of material to date. The matters I've just outlined mean that the victims and survivors I represent have not focused on particular chapters. Instead, what they've sought to do, and what I will seek to do going forward, is address two things. Firstly, I intend to make some submissions about the overall approach. And secondly, I intend to identify some themes that perhaps need to be considered. In terms of the overall approach, there's been reference in written submissions and earlier during this hearing to the need for a holistic approach. When I can make submissions later this morning, I will highlight a number of particular issues. And the preliminary issue list of issues also identifies a number of issues. That is to some extent inevitable. However, there is a danger in it. While the chapters provide a structure, it's essential not to consider any particular piece of evidence in isolation, but rather to approach the evidence in a holistic manner in order to identify any interconnectedness that may exist. And this may prove particularly challenging, we acknowledge, when there will be evidence held in open and closed. To give an example, though, of how a holistic approach is important, it is important not to assess any particular piece of intelligence in isolation without considering the potential that it could be related to other intelligence information. It is the full picture that enables an assessment of risk to be conducted. For example, intelligence may be obtained from an unreliable source. Corroboration for that intelligence may allow an assessment to be reached that it's more reliable than initially appears to be the case. To use a concrete example of this, the fact that dissidents were carrying out a series of bomb attacks potentially corroborated intelligence showing a desire and intent to carry out further attacks, indicating a risk. The importance of the points that I've just made is clear from evidence heard in a commission of inquiry in the Republic of Ireland into the fatal shooting in May 1998 of Ronan McLaughlin in Ashford, County Wicklow. During that hearing, a former detective sergeant, now chief superintendent, Peter Kerwin, stated that operational intelligence involved identifying a picture. The analogy often used is that of a jigsaw. The more pieces of the jigsaw you have, the more discernible the picture. If you have only one piece, it's unlikely you will be able to say whether it's a landscape or a still life. Once that picture is complete, or even if some of the pieces are available, it's disseminated to the relevant superintendents. Further, when reviewing the response of the state, it's easy to focus on the conduct of particular officers. By doing that, one risks failing to address the overall response of the state. For example, individual officers may have handled discrete pieces of information appropriately. That, however, does not mean the overall response was effective, as there may have been no assessment of the overall picture. That concern about the failure to assess the overall picture is supported by submissions I'll make later about the failure to share intelligence. One example of the need for a holistic approach arises in relation to the handling of the anonymous telephone call that was made on the 4th of August 1998. It explicitly identified Omagh as a target. The caller spoke for at least 10 minutes and stated that an unspecified attack would be made on police on the 15th of August 1998. 3 individuals were named and a 4th referred to by a nickname, and 2 addresses were provided. The caller stated that weapons, including AK-47s and rocket launchers, were to be brought on a given date and to be moved from a given address to an unknown address 2 to 3 miles from Omagh. This call was investigated by the Ombudsman, and it was reported that the call was dismissed by Special Branch as a fallout between smugglers. The police subdivisional commander was not informed of this call until the 15th of August 2000, contrary to Force Order 99/91, which required the subdivisional commander to be informed immediately when a threat is received. The Ombudsman was firmly of the view that this significant information was not handled correctly. Even assuming, which is not accepted, that on its own the call could be dismissed, the significance of it is potentially greater when linked with other material, such as that obtained from an agent, Kevin Fulton, suggesting that attack might be being planned. I'll come back to Mr. Fulton's material later. This demonstrates 2 matters need to be considered. Firstly, whether anyone within the state forces was in a position to carry out an assessment of the overall intelligence position and what that said about risk. And secondly, whether the overall intelligence picture required greater action from the state. Another topic that's already been touched upon is the issue of hindsight. In particular, several of the state participants warn against applying hindsight. The need to avoid hindsight is particularly important when considering the issue of preventability. The issue that arises, we submit, by reason of Article 2 is not whether the bomb would have actually been prevented by any particular steps. Such an approach is objectionable as it avoids the application of hindsight. The issue that arises, we submit as a matter of law, based on a judgment of the English Court of Appeal in a case called Sargentson, is whether there was a real and immediate risk that the state failed to take reasonable steps to address. Linked to the issue of hindsight, the PSNI opening statement indicates or argues that there is a need to consider other issues and threats the RUC was dealing with. In principle, this is not disputed. However, 2 matters need to be taken into consideration when considering the other challenges the RUC was dealing with. For reasons that I'll come to, and are probably obvious anyway, this was a time when the security challenges had reduced. This was not a situation when the state was dealing with a sudden, unpredictable upsurge in violence. Second, the UK is obliged to ensure that it has put the resources in place to comply with its obligations under Article 2 of the European Convention to provide protection. We refer in relation to that to another judgment of the English Court of Appeal, Norkiev. Therefore, the issue is not whether the actual resources available to the state could cope with the demands on them. The issue is whether the state put in place sufficient resources. In this context, it's noted from a report at the time for the Intelligence and Security Committee that it was said, for the security services, the renewed ceasefires in Northern Ireland led directly to a drop of over 5% in the service allocation of resources to Irish and domestic counter-terrorism. Therefore, an issue that potentially arises is whether the resources in fact were adequate to deal with the challenges that continue to be faced in Northern Ireland. That leads on to a topic I want to spend some time on, which is the security context at the relevant time. Obviously, everyone present will be aware that the bomb was planted after the Good Friday Agreement, which brought to an end the period which has become known as the Troubles. That is important, as it means the bomb was preceded by almost 30 years of terrorist violence. That was so intense at times that what had emerged by 1972 was described by one of the experts in their expert report as being an effective civil war. Although those 30 years were horrific and traumatic for the people of Northern Ireland, they did allow the state to develop powers, resources and experiences that were valuable in addressing the risks posed by terrorism. I'm about to address those resources and powers, but before doing it, it's important to notice that the Good Friday Agreement meant that the demands placed on those resources and powers were likely to be less than they had been for many years. Turning first to the resources, until 2001 and the establishment of the Police Service of Northern Ireland, law enforcement in Northern Ireland had been carried out by the RUC since 1922. However, in 1969, due to the level of civil unrest, the British Army were also deployed in Northern Ireland to support the RUC and continue to have a role in the security and protection of the civil population of Northern Ireland until the period of normalisation after the Good Friday Agreement. While the structure of law enforcement was at all material times relatively clear, the responsibility for intelligence gathering was more complex. That in part reflected history. In a 2002 briefing paper of the Security Service, it was said, the complex intelligence machinery in Northern Ireland was grown out of the history of security emergencies and the different complementary and supportive roles played in them over the years by the intelligence agencies and the security forces. There were attempts to address this complexity, for example, through the Walker Review. But what emerged was, and I quote, an unhelpful separation between the intelligence gathering and law enforcement sides of policing in Northern Ireland, and this resulted in the routine practice of intelligence not being shared with those investigating Troubles-related crimes on the basis that to share such information would risk exposing where it came from. The complexities were compounded by the fact that throughout the period of the Troubles, the pursuit of gathering intelligence and the management of agents was not governed by statute, but by non-statutory guidance and direction. At the time of the bomb, RUC, a special branch, had lead responsibility for gathering and exploiting intelligence on Republican and terrorist activity in Northern Ireland. It was structured into regions which reported into special branch headquarters, where units had responsibility for the assessment and dissemination of intelligence. Special branch, it was said, was of critical importance in the sphere of intelligence and ran the majority of agents in all terrorist groups. Special Branch's structure and workings had been reviewed in 1996 by Sir Gerald Warner as a result of concerns raised by the UK government about its operations. The implementation of that review had also been reviewed. That has two implications. Firstly, there should have been no structural reason why intelligence was not handled effectively by the RUC at the time of the Omagh bomb. Secondly, findings of other investigations and inquiries touching on the workings of Special Branch, such as the Canova inquiry that considered the period before Warner, need to be viewed with caution. Despite the RUC's role at the time of the bomb, at the commencement of the Troubles, the RUC was not in a position to lead intelligence collection, which prompted the British Army to intervene and forced it and other intelligence agencies to take the lead in obtaining their own intelligence. This resulted in a multitude of intelligence units from military, law enforcement and intelligence agencies all becoming involved and undertaking substantial roles. It's been reported that the organisational landscape with responsibility for intelligence gathering included some 20 units that formed or evolved between 1969 and 1983. While the British Army acted in support of the RUC, it was also involved in many aspects of intelligence, including the recruitment of handling agents through various units, including the Force Representation Unit, which operated with a headquarters and 4 regional units. The role of the FRU was explained by a former commanding officer as being to obtain intelligence from secretly penetrating terrorist organisations in Northern Ireland by recruiting and running agents and informants. The role is vital to counter-terrorist operations because only the inside knowledge provided by agents can lead to a true understanding of the terrorists and their intention. Similarly, 14 Intelligence Company played a role in gathering intelligence. In addition, the Security Service, MI5, the Security Intelligence Service and Government Communications Headquarters, GCHQ, also played a role in intelligence gathering. These services are high quality and have played an important role in disrupting intelligence. For example, MI5's website states, despite devastating bomb attacks on the Baltic Exchange and NatWest Tower, PIRA failed to achieve its aim. A Whitehall report commented, only a combination of good intelligence, good policing and good luck prevented several more incidents of such scale. Among other counter-terrorism successes was Operation Airlines, which in the summer of 1996 defeated a well-planned PIRA attempt to disrupt the whole of Greater London's electricity supply. It may be of some significance that the highlighted successes appeared related to London. As already noted, a significant issue is whether a differential and inferior approach was adopted to terrorism in Northern Ireland. With particular reference to GCHQ, it is known that they had the capacity and expertise to use electronic monitoring to track electronic devices and listen to telephone calls, and that the legislation would have allowed for the collection of that information whether or not it was inside or outside the United Kingdom. I'm going to come to some submissions about legal powers that demonstrate there does not appear to have been any effective restrictions on that material being passed to the police if it was in furtherance of GCHQ's functions and could be justified on the grounds of national security or to protect against a threat of a terrorist attack. One particular feature of the state's response during Troubles was the use of agents such as Kevin Fulton and David Rupert, who'd infiltrated terrorist organisations and gathering intelligence to communicate back to their handlers within the intelligence community. The running of agents has been viewed in Northern Ireland as, and I quote, one of the most effective methods by which the security forces could frustrate terrorist activity and save lives, and that, and I again quote, most valuable agents during the Troubles were undoubtedly those positioned deep within the terrorist groups themselves. The state did not merely receive information from its own resources. Material was also received from the Republic of Ireland. In 1998, in the Republic of Ireland, the Crime and Security Branch was responsible for the National Surveillance Unit and the intelligence service within the Garda. While it worked within the Garda structures, the NSU was a covert intelligence gathering unit which conducted its work separately. In 1998, most NSU duties involved following suspected members of terrorist organisations, with team leaders compiling a daily report after each tour of duty, which were entered into a ledger. The function of the intelligence service was to analyse information and intelligence about national security issues, which was received from various sources, including the NSU. National security in this context largely referred to counter-terrorism policing or policing of any group which threatened the state. The Emergency Response Unit, which operated under the umbrella of the Special Detective Unit, also worked closely with the NSU in 1998 and had responsibility for counter-terrorism work. As a general rule, and this is a quote, NSU stayed in the background as an undercover unit while the ERU was called in if there was a need to intercept or interrupt potential offences or to make arrests. The ERU was, as I've just made clear, used as a front line or intervention unit and was established to combat armed crime, and many of their operations in the late 1990s were counter-terrorist operations. However, the ERU did not generally have access to intelligence files. All of this demonstrates that the Garda plainly had the capacity to gather valuable intelligence. For example, it's reported that Garda Intelligence maintained an internal report containing the names and addresses of those believed to hold senior positions within the IRA. The issue of the effectiveness of cross-border cooperation in relation to intelligence will be something I return to. Overall, though, at this stage, I want to make clear that there is evidence of the effectiveness of intelligence gathering by the state. For example, as already noted, intelligence operations had successes. One example that you've already heard about was Operation Airlines. Another example of intelligence gathering being valuable relates to the Canary Wharf bomb. The Canary Wharf bomb is highlighted as an example of cross-border cooperation. However, it is, and I'll come back to this, unfortunately the case that it appears that cross-border cooperation may not always have been as effective as might have been hoped. The matters that I've just outlined, I've outlined to demonstrate that within Northern Ireland and the Republic of Ireland, there were an exceptional level of resources available to protect the public from terrorism. However, the resources, particularly those in relation to intelligence, were distributed across a number of organisations and units. That, we submit, inherently undermined the ability of any organisation to form an overall picture of the risks posed and the action required as a result of that risk. That, we submit, is an important issue for the inquiry to investigate. Turning then to the legal powers available to the security services and security forces at the time of the bomb. Since the origins of the Troubles, with the continuing and developing methods of terrorist activities that followed, there was a requirement to ensure that appropriate legal authorities were available to the state authorities in Great Britain and Northern Ireland. As John Wadham has said in his expert report, these were needed to seek to keep under surveillance, prevent or disrupt and or detect the activities of those suspected of being engaged in the planning and or the preparation for and or the carrying out of terrorist attacks. At the time of the Omagh bomb, the most important legislation was the Northern Ireland Emergency Powers Act 1996, which encompassed most of the powers included in earlier emergency legislation of 1973, 1978 and 1991. In addition, powers were found in the Police and Criminal Evidence Northern Ireland Order 1989 and the Prevention of Terrorism Temporary Provisions Act 1989, which preserved most of the powers from the Prevention of Terrorism Temporary Provisions Act 1974, which applied throughout the United Kingdom. The 1989 order and the 1989 and 1996 Acts provided the police, and in some instances the army, with exceptional powers to use against suspected terrorists. In summary, these included the following: the powers to initiate a road check, powers to wholly or partially close a road, powers to stop a person for so long as necessary for the purpose of ascertaining that person's identity or involvement or movements, or their knowledge of any recent explosion or any other recent incident concerning life or injury to life, to stop and search a person or vehicle if there were reasonable grounds for suspecting the presence of stolen or prohibited articles, or to stop and search anyone who appeared to be liable for arrest in relation to terrorism, to enter and search premises under warrant or without a warrant, to arrest without a warrant and detain a person initially for 48 hours with a further extension of 5 days. John Wadham, in his expert report, makes clear that these policing powers were exceptional. He states that the Northern Ireland Emergency Provisions Act 1996 and the Prevention of Terrorism Temporary Provisions Act 1989 gave the police and the army exceptional powers to use against suspected terrorists in Northern Ireland. These acts provided police officers and others with a wide remit to use their already significant powers under the Police and Criminal Evidence Northern Ireland Order 1989 to disrupt, question, search and arrest those suspected of acts of terrorism. These acts also created a number of special substantive criminal offences, including wearing uniforms and possessing information or articles where there was only suspicion that they were possessed for terrorist purposes. Those extensive, wide-ranging substantive offences extended the range of all the other policing powers because the threshold for their use was based on the investigation of criminal activity. Further, while police powers would now be constrained by the Human Rights Act 1998, so that wide powers of detention would be restricted, as is demonstrated by the case of Burgle versus the United Kingdom, this was not true at the time of the bomb. The powers available were not restricted to those relating to the policing of suspects. There were also a wide range of steps that could be taken to gather intelligence. According to the report prepared by John Wadham, covert investigations by law enforcement agencies were largely unregulated and could have included the surveillance of suspects or others, following a person or observing their movements or tracking them using electronic devices, or by the collection of geographic telephone cell site data, subject to that being technically possible, listening to conversations using listening devices placed in homes, buildings and vehicles, collecting data about telephone calls from telecom suppliers, accessing the content of emails and other messages, or at least by accessing the computer terminal, watching or recording computer or other devices keystrokes, subject to that being technically possible, using covert human intelligence sources, in other words, informers and undercover agents. The bomb occurred prior to the enactment of the Regulation of Investigatory Powers Act 2000, which now regulates surveillance in the United Kingdom. Therefore, in 1997 and 1998, in the absence of legislation, there were no general restrictions regarding the use of surveillance by law enforcement agencies. Some restrictions did exist for MI5, the Secret Intelligence Service, and GCHQ. Telephone interception and property interference were two techniques that were regulated for all law enforcement agencies. In relation to the interception of telecommunications, there were restrictions, but a warrant could be obtained from the Secretary of State for the required interception to be initiated, with the provisions applying equally to calls made from public telephone boxes or from an individual's home phone. While the Interception of Communications Act 1985 created a number of safeguards, there were also allegations made that between 1990 and 1997, GCHQ was intercepting all telephone traffic from the United Kingdom to the Republic of Ireland. There were restrictions in relation to the passing on of information about the existence of intercepts or the material derived from those intercepts, but this did not include a recording that took place in a telephone box, and that which could be relevant in the Omagh bomb when one considers the content of the cell site analysis. Furthermore, those restrictions on sharing the product of the interceptions did not apply where the disclosure was necessary for the purposes set out in Section 2, subsection 2 of the 1985 Act, which included national security, preventing or detecting serious crime, or safeguarding the economic well-being of the United Kingdom. Essentially, this could well have allowed the product of an intercept to be shared with any law enforcement agency where necessary to prevent terrorism. Law enforcement agencies would have had access to public and private CCTV systems and automatic number plate recognition camera systems. The police and intelligence service could have been authorised by the Secretary of State to trespass on land or damage another person's property. These are further powers that could be used to obtain intelligence. At the time of the bomb, an individual's right to privacy would have been considered very weak under common law. That was significant as the Human Rights Act had not come into force. In many situations, the law would not have prevented most activities regarding law enforcement because simply their activities would not have been deemed unlawful. The courts had previously decided in a case that there was no right to privacy in law, including any particular right of privacy in relation to telephone calls. Therefore, it appears that during the time leading up to the Omagh bomb in 1997 and 1998, there were few protections or controls on surveillance, and that the real limitations were not legal or regulatory, but rather technical or scientific limitations at the time. The key points about the powers I've just been outlining are: firstly, many of these powers appeared to be exceptional powers directed at the challenges posed by terrorism in Northern Ireland. That is demonstrated by the name of the legislation and the fact that equivalent powers were not enacted in England. Secondly, although no legislative scheme can eliminate the threat of terrorism, the experience gathered by the Troubles is likely to mean that the state had all powers that it needed and that were consistent with the human rights of the civilian population. Thirdly, these powers potentially enabled significant steps to be taken to disrupt terrorism. For example, suspect terrorists could be repeatedly stopped to both make it clear they were of interest and also to potentially obtain intelligence regarding that person's movements and their associates. Finally, the powers also potentially enabled significant steps to be taken to gather intelligence. Indeed, as already noted, intelligence gathering was a key part of the state's response to the Troubles. The knowledge and experience gathered and developed by the British intelligence services has been well documented. To quote one author, the British tried almost every conceivable form of emergency power to quell the violence in Northern Ireland over the 30-year period. Having considered the state powers, can I then go on to the political and address them as part of the context? Can I go on to the political context?
Mr. Southey,
Yes.
it will be important for us to take a break for the assistance of the stenographer, apart from anything else. You're just about to touch on your next heading.
Yes.
You've been speaking for an hour. Would this be a suitable point?
This would be a very suitable moment. Thank you.
Thank you. Well, we'll take a short break at this stage.
When we broke, I'd made a number of submissions about intelligence, and in particular the issues that related to intelligence sharing. Linked to that is another topic I just wanted to touch on, which is the absence of rules and guidelines regarding the use of intelligence. At the material time, it appears to the victims and survivors I represent that despite various requests and reports that sought a proper set of bespoke guidelines for the management of use of agents in Northern Ireland, there was no formal protocol in place. As was stated in the interim report of the Canova inquiry, the use of agents by the security forces in Northern Ireland was not the subject of any meaningful, effective or enforceable legal or policy framework during the course of the Troubles. Similarly, the corporate statement of PSNI states there were no special branch guidelines for Northern Ireland issued by the executive arm of Her Majesty's government, which would include guidance on gathering and managing intelligence in a Northern Ireland terrorist-related policing context. This was an issue repeatedly raised by the IUC with Her Majesty's government, in particular the absence of guidelines and or legislation on agent handling. It's clear that the IUC was unhappy with the situation as it stood at the time, and that it continued to raise the issue with Her Majesty's government. The absence of any rules or guidance governing the use of informers potentially had two consequences. These were, it potentially permitted, firstly, the development of intelligence silos based on intelligence that wasn't shared. In addition, it potentially allowed risks to be taken with public safety, despite intelligence suggesting risk. The submission that risk could be taken with public safety is supported by clear findings in the past that the focus of intelligence handling was on protecting agents, and that as a consequence there was a great degree of tolerance of terrorist activity. For example, it was said in the Canova interim report that the potential operational priority for security forces was the continued acquisition of counter-terrorist intelligence, and this meant the protection of established agents from compromise. If acting on intelligence about a risk to life might bring its source under suspicion or blow their cover, the intelligence would often be withheld or at least not acted upon. The victims and survivors I represent are not in a position to know on the state of the evidence whether it is arguable that any inaction in relation to intelligence was motivated by a desire to protect state agents. However, the victims and survivors that I represent submit that the evidence regarding prioritising agent safety over public protection is potentially relevant because, firstly, it demonstrates that there is a need to subject any apparent inaction to careful scrutiny. It cannot be assumed that state agents were always primarily motivated by a desire to protect the public. For example, the evidence regarding the handling of intelligence from Kevin Fulton should be considered taking account of the possibility that the protection of Kevin Fulton was seen as a priority. More generally, the material about inactivity or desire to prioritise the protection of state agents demonstrates that there may have been motives for declining to share key intelligence. A further issue linked to intelligence that the victims and survivors I represent would wish to raise is that relating to loss of records. I've already drawn attention to the fact that Kevin Fulton provided intelligence on the 12th of August that the real IRA was to move something north over the following few days. The contact sheet for this meeting and for the meeting on the 23rd of July 1998 could not be located in special branch records. In his response to the Police Ombudsman's report, the former Chief Constable Sir Ronnie Flanagan admitted that due to, and I quote, an unacceptable breakdown in procedure and an administrative error, 2 of the 5 intelligence reports based on information from Kevin Fulton in the period from June to August 1998 were never passed by RUC Force Intelligence Bureau to Special Branch. Although the implication of Sir Ronnie Flanagan's statement was that material had been lost accidentally, there are possible motives for it being deliberately destroyed. A detective sergeant in RUC CID, referred to as W71, who was Fulton's handler at the time of the Omagh bomb, gave evidence to the Smethwick Tribunal that he was informed by Special Branch on the 20th of August 1998, 5 days after the Omagh bomb, and by Sir Ronnie Flanagan during a telephone call, that Keeley, or Fulton, was an intelligence nuisance. That raises issues as to whether Fulton's intelligence was discounted wrongly. If that is the case, records may have demonstrated that, and there was an incentive to withhold them. W71 also gave evidence that I also phoned intelligence through to various departments. It would be surprising if the various departments had not kept records. It's surprising, therefore, that it appears that all records have been lost. The victims and survivors I represent have also raised questions pertaining to the whereabouts of the threat book, which has never been located and which should have contained all information about threats received, including the content of an anonymous phone call on the 4th of August 1998. As noted already, there are good reasons to believe that sensitive material has been withheld in the past from official investigations. It has already been submitted. This means that claims to have provided full disclosure should be scrutinised with care. That is supported by the fact that material has apparently been mislaid in this case in the past. Overall, in relation to intelligence, it's submitted on behalf of the victims and survivors that I represent that the material I've just drawn attention to demonstrates how it's important to investigate with rigour. Firstly, the extent to which intelligence was gathered before the bomb. Secondly, the extent to which intelligence was properly shared. Thirdly, the extent to which there was an appropriate response to that intelligence. That includes whether the response to bomb threats was adequately updated in light of intelligence. A separate topic that is of importance to the core participants I represent is the issue of the linked incidents. The Omagh bomb was clearly not a one-off isolated incident and followed a series of linked attacks in 1997 and 1998. With an increase which was part of an increase of violent dissident Republican activity. While publicly it may have been claimed that these attacks were undertaken by separate entities, the experts would suggest that there was active cooperation and coordination between the dissident groups. It has been suggested in his role as Director of Operations of the Real IRA, Liam Campbell had developed an operational coalition with the Continuity IRA and the INLA. It has also been suggested that following the split, there was evidence of cooperation between the Real IRA and the Provisional IRA when Semtex-based detonating cord and two Irreco detonators were found in a 230-kilogram bomb defused at Banbridge and attributed to the IRA. These matters demonstrate the importance of adopting an inclusive approach to prior incidents. Prior incidents should be considered even if not attributed to the Real IRA. It's recognised that the evidence gathering in relation to these earlier incidents is at an earlier stage. The victims and survivors I represent are grateful to the priority that is being given to that evidence gathering by PSNI. At this early stage, the victims and survivors highlight the following matters as being potentially indicative of the fact that earlier incidents needed to be fully investigated or need to be fully investigated by the inquiry and or may demonstrate that the bomb could have been prevented. Firstly, and the issues that arise we submit are as follows. Firstly, an issue that I've already raised at other points of these submissions is the issue of whether there was differential policing and or greater tolerance of terrorist violence in Northern Ireland. That means that there is a need to consider whether the prior incidents would have resulted in greater action had they occurred in Great Britain. The concerns that I've just expressed are supported by the fact that in his evidence to the Northern Ireland Affairs Committee, Mr. Baxter, who was in charge of the bomb investigation from 2000, stated that the Omagh bomb might have been prevented had earlier action been taken against those involved in other incidents. He said, and I quote, "There could have been opportunities to arrest this gang after Lisbon, after bombs in May, June and July, even after Banbridge. If we take Lisbon, which is one of the linked incidents, a car bomb, there was an opportunity, had the investigators been given the identities of the bomb team, to carry out searches of the properties or the homes of suspects." He also stated that certainly disruption could have prevented it. Those remarks need to be considered in light of the submissions that I'd already made, that the state had both powers and resources necessary to gather relevant intelligence and then take disruptive action. Another topic that the core participants that I represent would wish to raise is the need for an overall assessment. Depending upon the evidence that is heard regarding the issues, one of the concerns that is raised on behalf of the core participants I represent is whether there was a need for a designated decision maker with responsibility to assess all of the material that may have been available in order to assess what steps needed to be taken to protect the public. For example, was there a need to develop a better response plan to threats such as the threat received in Omagh before the bomb? A further issue that I've touched upon already, but I just want to highlight again, is the issue of differential policing. In his evidence to the Northern Ireland Affairs Committee, Mr. Baxter stated, "I think it's inconceivable on mainland United Kingdom, if you had a series of of bombs happening every week or two, that there would not have been arrests and there would not have been government intervention to ensure that this team was disrupted." One reason to be concerned about differential policing is that, as I've already indicated, MI5, for example, appeared to claim particular success in relation to the disruption of terrorism in London. A further reason to be concerned about this issue is that PSNI's corporate statement appears to suggest that a different approach may have been adopted to the handling of intelligence in Britain to that adopted in Northern Ireland. All of these matters raise concerns that it's submitted are legitimate concerns that need to be examined with particular care. The final topic that I want to raise in this opening is the issue of cooperation with the Republic of Ireland. There is little or no doubt that dissident Republic activity linked to the bomb took place in the Republic of Ireland. That suggests that effective protection of the bomb potentially required the assistance of the Republic of Ireland's authorities. The victims and survivors encouraged the government of the Republic of Ireland, as I've already indicated, to establish a procedure that will enable findings to be reached regarding any failings that may have occurred within the south of Ireland. There is reason to believe that intelligence was known by the Garda but not the RUC. The Omagh bomb investigation team presented a briefing paper to some of the families of the bereaved and injured, the Omagh support and self-help group, on the 22nd of February 2008, which stated, among other matters, firstly, that intelligence material indicated that in November 1997, dissident Republicans discussed the military and police bases in Omagh. That information was not passed on to the RUC, and therefore the sub-divisional commander in Omagh was not made aware of this information regarding the military bases or his own station. The investigation team assessed that this information should have been passed on to the RUC at the time, bearing in mind the number of terrorist bombs and attempted bombs in 1997. In addition to that, following an operation by the Garda in April 1998 to disrupt a dissident operation, A generalised document was provided to the IUC which was said to lack sufficient detail. More generally, there appear to have been mixed descriptions of the cooperation between the police forces on both sides of the border. The Smithick Tribunal suggests that there was close cooperation at a local level across the border, particularly between police forces in Newry and Dundalk. The Nally report refers to close counter-terrorism cooperation both formally and on a personal basis, and that cooperation was excellent. However, as I've already outlined, in the corporate statement of PSNI, there are statements that suggest preventative material in particular was not shared. Although findings regarding the conduct of Irish state authorities are not a matter for the inquiry, there are clearly findings open to the inquiry. These include whether information of value was received from the Republic of Ireland, whether more could have been done to improve the supply of information from the Republic of Ireland, and whether any information of value received from the Republic of Ireland was effectively deployed. That covers the issues that we want to highlight, or that the core participants I represent want to highlight at this stage. As I've already noted, the victims and survivors I represent are not seeking at this stage to argue that particular findings should be made. The victims and survivors I represent believe that it's important that the inquiry keeps an open mind. However, the victims and survivors argue that it's clear that there are difficult and important issues containing a range that arise in relation to a range of matters that need to be considered with care. The victims and survivors I represent appreciate the commitment of the inquiry to get to the truth. The range and importance of the issues, though, mean, among other matters, that firstly, it's important that victims and survivors are able to participate fully in the questioning of witnesses, including by asking questions directly. Secondly, victims and survivors' interests are advanced in closed by special advocates. And thirdly, there is full engagement by the Irish government. Thank you. That concludes the opening statement on behalf of the victims and survivors I represent.
Thank you, Mr. Southey.
Thank you.
So would you rise for about 5 minutes, following which we'll hear the final opening statement delivered by Mr. Mansfield, who, as I said at the beginning of yesterday, will be appearing by a video link.
Yes. Mr. Greenie.
So we'll now hear from Mr. Mansfield, who will address you on behalf of the Rush family.
Good afternoon, Mr. Mansfield.
Good afternoon. May I just go straight to make sure, am I being heard loud and clear, and can everybody see? Is that all right?
You are, yes. Thank you.
Thank you very much. I wanted to also thank you for allowing me to do it this way. As you know, I had an injury, but by the next hearing, I hope to be in person because I prefer that. As you know, I appear together with Nicola Rowntree, and we're instructed by Desmond Doherty on behalf of Libby Rush, who died in this atrocity, her husband, who died later in 2012, and her daughter, Siobhan, who I think may be there today, and her two brothers, Anthony and Andrew. So what I intend to do, as you will see, we've done a relatively short, open, written statement. And I am going to read it, but I will break off occasionally, hopefully not too much, and not at length, to incorporate observations on matters that have been put before you yesterday and again some today. And the reason for reading and using this statement in the way it's quite probably different to some of the others is because it does provide for you, and you know a lot already, but it provides for the public a narrative and a genesis, in a sense, of this whole inquiry. And it also explains this particular statement. Not only Lawrence Rush's concerns were he to be here to make observations, but also the rest of the family, explains their concerns about observations that were made yesterday and a few more today, as to why they hold these worries, sentiments, and undoubtedly a long-standing, deeply held belief that the truth is the object and they're going to help you and your team. And the Rush family wish to extend their continued gratitude to you, the chair, and the inquiry team for their professionalism, courtesy and commitment to the inquiry, particularly the last set of hearings, which were commemorative. The terms of reference set out in the key areas of analysis for the inquiry, but the issue of greatest concern to the Rush family, and it is, of course, I have the terms of reference in front of me. I'll come back to them in a moment, but it's quite clear that the core issue for the inquiry is preventability. And that is what is of the greatest concern to the Rush family and requires rigorous investigation, which they're perfectly satisfied you will provide. Often described as the worst atrocity of the Troubles, the Omagh bombing on the 15th of August 1998 altered the trajectory of life for so many. What was set to be a peaceful time in the aftermath of the Good Friday Agreement descended into confusion, chaos, and utter devastation. For the Rush family, and so many others, it was a trauma which shaped so many generations. The grief, the unimaginable loss, has been compounded by the long and arduous path to get to the truth, being met with a wall of silence, the self-protection of the state authorities, the lack of accountability, the closing down of ranks has only further intensified the unresolved allegations which have become corrosive over the past 26 years. I'm turning now to the inquest, which I attended with my instructing solicitor. That occurred in the year 2000. Now, these are important events in terms of not only providing a backdrop, but actually providing you with necessary inquisitive, because you are essentially, it is an inquisitorial process, as you know, inquisitive questions that might need to be asked. And after a section, I'll just stop and suggest where we're going in the light of what has been said yesterday and today. So the inquest happened in the year 2000, so there's been a gap of almost 2 years from the incident itself. The Rush family, Lawrence Rush, adopted a position over 2 decades ago that the bomb could have been prevented. In the year 2000, Lawrence Rush took a stand at the inquest, a lonely figure in the inquest. He asked difficult questions and gently probed at sensitive issues which others sought to shy away from. He was criticized, at times ridiculed. His family lived in a state of fear in case matters escalated beyond words. But he remained steadfast in his suspicions that the full picture was being airbrushed and the truth withheld from the families and the public. This is now the very subject matter that this inquiry is tasked to deal with 2.5 decades later. You, sir, acknowledge the unique and difficult path the Rush family took at the commemorative hearings, describing Lawrence Rush as a campaigner for truth and justice from a very early stage, who sought to cast light on the circumstances surrounding the bombing and tried to learn about previous attacks, what was done and not done. You acknowledge that he was the first to raise some of the questions the inquiry has to determine and not deterred from speaking them loudly and publicly? These questions are still uncomfortable for so many. Lawrence Rush may not have known the full truth about how or why the Omagh bombing happened before he died. That was in 2012. But he had a genuine and honest belief that the state narrative about the bombing didn't make sense. And at the time of the inquest, he was convinced there was more to it. His daughter and 2 sons still view the state narrative about the circumstances of the bombing as illogical. The stance adopted by Lawrence Rush drew virtually no support from any quarter in society. And this had a profound impact on him. He was very much alone in his search for truth and accountability. It was a fact, and of course acknowledged by everyone, the real IRA murdered his wife. They claimed responsibility for the bomb, and that's how it should remain. He had to grapple with this extremely distressing fact, whilst also trying to understand how something like this could have happened without state authorities having any suspicion, or worse, actual intelligence about the bomb. He had great difficulty articulating and arguing that he felt that the bombing could have been prevented by authorities of the state, and at times did not want to believe this himself. He challenged himself many times because of doubt and, of course, because of hostility from others. However, ultimately, his determination did not wane, and fueled by the love for his wife and family she'd left behind, he continued to search for answers. Now, if I may, I'm going to pause at that moment, because what I want to do is, just bearing in mind the 2 pages I've read, deal with the question of the response by the state authorities yesterday. And they're really indicating that, we should be sympathetic, which we are, to the difficulties of amassing information. This is an important job. However, it cannot be said that they were not aware. I don't mean the individuals now concerned. I'm talking obviously of continuity here. It cannot be said that government departments were not on notice. The date has been specified today since 2021. I'm sorry, it's much earlier than that. And if I'm trying to put an element of reality in this, once this happened on the 15th of August 1998, are we to imagine that state authorities didn't immediately have meetings? And these meetings are important. I don't know how they all happened. There are various different ways you can have meetings. And the meetings they must have had, which should have ensured the preservation, not, oh, we only got notice yesterday. The state has known since this incident. This was an incident termed, as I've already indicated, the worst atrocity in peacetime. An incident which comes after the Good Friday Agreement. Therefore, there are going to be massive questions, and not just asked within the United Kingdom, but asked within the United States, because of their participation in this, not only at the intelligence level, but at a higher level as well, which I'll come back to a little later. So what they must have done, and if they didn't, I think there have to be concessions fairly soon, and I'll come back to that as well. This all bears on observations made yesterday. The difficulties that they're facing, not, well, in a sense indirectly, but are facing the state, are of their own making. Because if they didn't sit down at that time, or whatever they do, and ask the basic questions, and on this, may I say that the terms of reference are extremely apposite and very well focused. I'm not going to read them all out, but is it to be believed that the state on the 16th of August 1998 didn't ask themselves, and this is the scope part of the terms of reference, and A, the assessment by UK state authorities of the threat posed in Northern Ireland by dissident Republican terrorists from the 1st of December 1997 to the date of the Omagh bombing. This shall include consideration of any change in the assessment. That is absolutely crucial. Are we to believe nobody asked themselves that question? And where are the records relating to that question? And where are they? And if they aren't being preserved, we need an explanation now. And I come back to it under the concessions. These are basic questions that must have been asked then. They don't need to be getting a letter or a writ or a summons before they ask these questions. So the state, not holding them responsible for the bombing in the sense that the real IRA are, but we are saying that they have a responsibility for safety. So if they did ask about these questions, what were the answers? And of course, risk assessment is at the center of this. And it's already been explained what the risk might, terms of the risk might be implied by the European Convention and Article 2 and so on. That's the first question. Second question, these are all basic. The adequacy of measures taken by the authorities to disrupt the dissident Republican terror. Again, you don't have to be at a university level to work these questions out. They're not born from hindsight. If you were sitting there, I was sitting there, and I'd had relatives killed in the high street at Omagh, just as we heard yesterday very movingly from council, you would ask that question. Who did this? Who's claimed it? What have they done before? Where were they? Where were we? I mean, one's trying to introduce an element of realism into this, that there's all very well relying on, well, it's a long time since it happened. Sorry, I'm talking about then. What happened then? What were they doing then about these questions, which are entirely proper? This is the third one, which is obvious again. The adequacy of policies and practice of the UK state authorities, including the police, security forces and intelligence and security agencies, in sharing intelligence. Well, again, it's a question you're bound to ask. Did we know about this? If we didn't know, why didn't we know? Now, these are questions that need to be asked in your inquiry, and I'm absolutely confident, and so are the Rush family, that your council will be asking them and sometimes occasionally maybe you will be asking them yourself. So they've been on notice since 1998. However, it gets more specific in the year 2000. And I can say this because obviously I was there at the inquest. They were absolutely put on notice in the year 2000, not 2021, but 2000. May I just list the issues that arose in the inquest and why Lawrence was isolated in the way I've described. The issues that were one main issue which arose at the inquest is, why was the army, we've heard it today from Mr. Southey before me, why was the army not deployed that day? They were there in Omagh. They could have been deployed, so why weren't they? First topic. Second topic, warnings. We went through that. We didn't have all the information that we now had, but we understood there were warnings, including the one on the 4th. So that was an issue then. Intelligence was an issue then, general intelligence, but if there was any relating to Omagh. The possibility of disruption. What we were talking about then was roadblocks, intercepting vehicles, and so forth. Fairly basic. So even if you don't know which vehicle you close the town on, yes, it's a risk. However, the risk here is you've got a dissident group who've made their path very clear over the previous year. So if there's any information coming in and you've got somebody who's inside the organization, you have a precautionary approach, particularly in the aftermath of the Good Friday Agreement when so much was at stake. So these linked incidents were asked about, Banbridge particularly, but ones before that. We didn't have all the information that you now have. So we say, when the authorities say, as they did yesterday, sorry, it's going to take a long time to get there, and actually we've lost a lot of documents anyway, some of which have been outlined today. Horrific, shocking was the description given, that the meetings at a certain level which were happening regularly, which I suggest were happening on the 16th and possibly the 15th of August 1998, that we don't have the records. Well, if we don't have the records, they better have a very watertight explanation other than, well, we can't tell you. So I paused there because this question of notice and disclosure and concessions, because what I'm going to read now from the statement that we make is the struggle that Lawrence Rush had after the inquest to try and make his point wider than just the questions asked at the inquest. So I'm on paragraph 6 if you're following a copy of it. Baroness Nuala Alone's police ombudsman report dated the 12th of December 2001, so that's 1 year after the inquest, raised some potential issues about the use of and dissemination of intelligence between various agencies within the police at the time. She criticized the police for their response following the event and missed opportunities to properly investigate the bombing. Lawrence Rush had been struggling with doubts and unease about the circumstances surrounding the bomb. This report gave him hope and, in a sense, of vindication for his feelings. He felt that there was finally a light being cast on the actions of the authorities. These findings acted as a catalyst for further investigation. Over the course of the next few years, others began to see what Lawrence had seen from the start, gaps in the narrative, obscured facts, evasive answers, and things that simply didn't make sense. And the Rush family are indebted to Baroness Alone for exposing some of the issues their father sought to bring to the fore and extend their gratitude and respect to her. Given the political landscape at that time and the controversial issues raised, her courage should be recognized and will not be forgotten. I move to the litigation that Lawrence Rush was driven to initiate. You recognize also that Lawrence Rush was the first to issue litigation against the police and the British government. This was not action which was taken lightly, but rather after many legal consultations and after much deliberation. It was the view of Lawrence Rush that this was a necessary step to uncover the truth. Previous inquiries actioned by him and others had resulted in many dead ends, and the family were running out of road. Lawrence Rush litigated in the High Court against the Chief Constable of the PSNI, formerly RUC, and the British government on the 17th of July 2002. So here's another date in the chronology, as it were, whereby the idea that they can only the need to get things together now, when in fact they must have been getting things together much earlier. And here's another stepping stone in that. Some 23 years ago and 1 year following the publication of the report of the police ombudsman. The cause of action itself, that Libby Rush, this is words taken from the cause of action, Lawrence's wife was murdered on the 15th of August 1998 by reason of the negligence, misfeasance in public office and breach of the statutory duties of the police and the government in their failures in the apprehension, detection and preemptive arrest of members of a criminal terrorist conspiracy, namely the real IRA, who planted the bomb, which led to the explosion in which Libby Rush was murdered. In other words, he was saying, firstly, that the bombing could have been prevented by the relevant authorities, and his wife's right to life was not protected by the state. Secondly, in addition, he said that her murder was never properly investigated. This has always been and remains the Rush family position. The litigation was a difficult chapter in the Rush family history. The mental toll of controversial litigation had an obvious impact on Lawrence Rush. There was fierce resistance by the authorities to information being disclosed into the public domain, and the Rush family feel strongly that this resistance was deliberate to prevent difficult questions being asked. And we would ask this to be borne in mind now in relation to disclosure by the authorities, even at this stage. Lawrence Rush, through this litigation, 2002, presented to the court an alternative narrative. As part of his legacy, we wish to put this formally on the record for the inquiry, reminding everyone that these issues were raised by him 25 years ago. He said from the beginning, and I quote from the pleadings referred to, a proscribed organization, a so-called real IRA, planted a bomb in Omagh. That proscribed organization had been infiltrated by an informer, one Kevin Fulton, who you've heard a lot about today, who fed to the security forces information sufficient to have prevented the bombing. And of course, the documents which have gone missing, mentioned by Hugh Southey moments ago, are particularly pertinent, the one on August the 12th, the so-called missing. The police and government, or one of them, had sufficient quality of information to apprehend the perpetrators or prevent the planting of the bomb. The police in particular failed to take such steps as would have prevented the loss of life by failing to stop the bombers or apprehend them in time or at all, as a consequence of not acting on intelligence to ensure that no car bomb was planted in Omagh on the 15th of August, 1998. Throughout the years of litigation, the Rush family answered every question asked of them. There was much back and forth in the pleadings, and ultimately, the Rush family named a number of individuals and agent handlers in the course of their answers, 2nd of April 2004 and on the 12th of October 2004. The full set of pleadings has been provided to the inquiry, and we would ask you, sir, to analyse these closely. We say there is evidence which is capable of suggesting that the state authorities could and should have prevented the bomb. Another important turning point for the Rush family was the Panorama documentary aired on the 15th of September 2008. Following this documentary, the civil pleadings were expanded as follows. Firstly, that the defendants in the action, through their agents or servants, namely GCHQ Communications Centre at Cheltenham, Gloucester, had contemporaneous intercepts of the bombers' mobile phone communication on the afternoon of the 15th of August, 1998. The said communications centre had actual knowledge of the route of the bombers and their target being Omagh. This information was not acted upon to either apprehend the bombers or put into operation a comprehensive evacuation strategy of Omagh, mindful of the intent of the real IRA, which had demonstrated some weeks previously when a bomb was planted and exploded in Banbridge. The threat and the capacity of the real IRA were known to the police and government in consequence of that previous bombing. The circumstances of the transportation of the bomb to Omagh could not have been more serious, and the defendants failed to react, either in time or at all, to prevent the loss of life to Libby Rush. There was a failure to have in place a clear, precise, and expeditious method excuse me, for transmitting the intelligence received by GCHQ to the police that would have prevented the bombing. The context and timing of these submissions made by the Rush family is important. This was unpopular litigation, and many struggled to support Lawrence Rush. There was a complete blanket denial by the authorities. This, we say, is an important paragraph, because as you will see in a moment, I'm going to pause again for reflection on how the authorities are dealing with it now. Efforts were made by the authorities to strike the litigation out. In 2009, the case was described by the police and government as frivolous and vexatious, even unarguable and unsustainable. Strong and confronting words for any family to hear. And we are yet to hear a retraction on the part of government, which I'll come to in a moment. The application to strike the litigation out was a private in-camera hearing before the High Court, at which only Lawrence Rush and his legal team were permitted to be present. Later, he was permitted to bring a family friend in view of his failing health and the requirement to travel. There was no public element to the hearings in that initial process, which is in stark contrast to the public and open nature of this inquiry, which we know will be transparent, conducted by you. The initial application was struck out on the 18th of May 2010, and we give the reference. Another setback for the Rush family, and other families perhaps in similar situations might have just given up, but he didn't. But later reinstated on the appeal. 2011, Lord Justice Gillen, in his judgment, did not accept that the position adopted by Lawrence Rush was unsustainable. Towards the end of his judgment, he said, "I've come to the conclusion that it's neither plain nor obvious that the cause of action in this matter has no chance of success. In short, I do not consider that on the pleadings, the case made by the plaintiff is unarguable." By this time, Lawrence Rush was in a nursing home, and sadly his health was deteriorating rapidly. He was comforted by the words of Lord Justice Gillen, but there was still a long road ahead. The litigation had many twists and turns. The process of obtaining disclosure and documentation was tiresome and frustrating. There was inordinate and unjustifiable delay by the authorities in providing information. The Rush family had to obtain a court order to secure discovery. That is why I pause for a moment. The families find it difficult. They want to believe they're going to get cooperation. They're difficult to believe that we're going to get full disclosure, or rather, you're going to get it, because some of it plainly will not be available to us, although we hope and endorse those sentiments that as much as open should be made. The initial writ of summons issued in the High Court was dated 2002, and the Gillen judgment is dated 2011. There was a discovery order for documents dated 2014. It all moved at a glacial pace. Some documents were eventually disclosed, and these have been provided to assist the inquiry. Sensitive documentation was not provided. These civil proceedings were ongoing at the time of the litigation commenced by Michael Gallagher, and together these two sets of legal proceedings complemented each other. Two men, two families, searching for truth and accountability. In the civil litigation, there was a blanket denial of everything pleaded by Lawrence Rush. In the initial statement of claim on the 21st of January 2004, Lawrence Rush pleaded that the defendants, that is, RUC, PSNI, or government, or one of them, had sufficient quality of information to apprehend the perpetrators or prevent the planning of the bomb at Omagh on the 15th of August 1998, which directly caused the death of Libby Rush. In the defence to this litigation, served on behalf of the police and government, dated the 8th of December 2004, the first named defendant, the Chief Constable of Police, further says that he and his servants or agents are not responsible in law for the operational decisions, acts or omissions of the second named defendant, the government, in respect of crime prevention and or crime detection, investigation, and none of the allegations of negligence properly are to be viewed as within his area of responsibility. The Rush family ask you, sir, to conduct a root and branch review of the practices and the oversight of the police and government agencies. Now, this is the kernel of our statement. The Rush family do not seek to criticize or blame officers on the ground in Omagh. And I think none of the families want to do that on the 15th of August 1998, but rather those who had oversight of decision-making, those involved in accessing information, intelligence agents who were making high-level decisions in both police and government agencies. And we know now they were meeting regularly and there was regular contact, but we don't have the record. But those are the people that the family of Libby Rush wish to have questioned, at least in terms of if they're still alive, in terms of the documentation that is available. Who made the decision about the distance of evacuation for the explosion? Who made the decision to deplete the number of officers in Omagh on that particular morning? Who made the decision not to act on intelligence received, not to pass on information? Just a sample of the questions to be answered. The officers who were there on that day were clearly doing their best in horrific circumstances, and the Rush family extend their gratitude to those who tried to help the bereaved and the injured. Lawrence Rush died on the 4th of March, 2012. He died without answers. That is a source of great regret for his family. I'm going to pause again at this stage to deal with another observation. And so we take this particular matter, it's not just a procedural matter, it's absolutely vital, we say, to the transparency, the alacrity, and the scope of this inquest. I'm so sorry, inquiry. I was just about to talk about inquest, which overlaps. You asked in the protocol and set out very clearly that you expect state court participants to understand and exhibit the principles of the Hillsborough Charter and the Hillsborough Law. You expect openness, candour and transparency. In the event any state court participant has identified mistakes or failings going to the terms of reference, 3 of which I've read, there are in fact 9, but I'm not reading them all out, has identified mistakes or failings going to those terms of reference, these must be fully and clearly acknowledged in plain language, cross-referring to the terms of reference and the provisional list of issues. You go on to state court participants can expect scrutiny of their opening statements in the context of what subsequently emerges. Now, I know your counsel opened these matters, and I wish, on behalf of the Rush family, to endorse them, because both he and I have appeared in previous matters, one of which was the Hillsborough inquest, as opposed to inquiry, and I've appeared in the Grenfell inquiry as well. These are not, it's obvious, and you've said it many times, these are not adversarial, these are inquisitorial processes. And it is extremely important that those who have the materials, which of course is the state authorities here, in fact have had them for 25 years, and they're now saying to you yesterday, it's too early because we haven't heard any evidence. Excuse me, this sounds very much like a process whereby a defendant waits to see what's produced before they say anything. These are not criminal proceedings. And we say the state authorities must be pressed now, not next week, not next year. They must be in a position, otherwise it's more than serious negligence if they don't know where they stand on some of these basic questions. There's quite a lot they can already, we say, concede. For example, if it's going to be missing documents, let's concede that straight away. And that's why something didn't happen, with an explanation. It'll make life for everyone, including obviously yourself, far easier and, of course, far more transparent. And the idea that they don't say anything and they keep their mouths shut until the first witness, we say is a disgrace. That should not happen. And also, may I just add an extra part of the protocol, which we say is important. In the event there are mistakes or failings which a state court participant considers can only be acknowledged and closed due to the risk to national security, an account of those failings must be provided in writing to the inquiry legal team in a closed environment at the same time as the open written statement. Any closed document should be accompanied by an application for a restriction order justifying why these concessions cannot be made in open. The chairman expects both open and closed versions of any restriction order applications or clear justification for why no open restriction order application can be made in the closed application, and then upon the receipt of these documents. Now, the question we have on behalf of the Rush family, have you had anybody, or particularly state authorities, providing you, obviously we don't want to know what the information is, that's obviously it would be completely counterproductive. But has there been any closed? We get a hint of it, obviously, with the Ombudsman's statement yesterday. But has anybody else provided you with a closed statement as to why they concede certain things, but they can't, and you've had to, as it were, consider these matters and decide they stay closed or they should be open? So the answer, I'm not asking for an answer, obviously, at this stage, but we say this protocol is extremely important because the problem faced in Hillsborough, which was inquest, in Grenfell was exactly the same. And what happened in Hillsborough was that the learned High Court judge dealing with the inquest insisted that the state authorities make a position statement of what their position, otherwise we wouldn't have known where they were coming from or what they were trying to say or what point was, what they accepted, what they didn't. So they were each made to do that. It was the first one I've known where that actually happened. In Grenfell, it was expected and happened that when the openings occurred, state authorities would make clear what they accepted. And interestingly, what happened in Grenfell was the state authorities accepted certain aspects of responsibility, but the private corporations didn't. But I don't go into it any more than that, other than to say what you set out in this protocol is vital to the lifeblood of this inquiry, that we know now, the families know now, they've waited long enough, what they're prepared to concede. And if the answer coming back within 28 days or the time of the next hearing in July, if they're still unable to do that, then I think there has to be a far more, well, it speaks for itself, may I say, res ipsa loquitur, as they say. So that's the pause I've made. I'm sorry, taking a little longer on that. Coming to the end of this statement. When he died, that's Lawrence Rush, in 2012, the family made a decision to await the outcome of the other legal processes to see if they could make progress regarding the provision of documentation. It was clear from the decision of Justice Gillen, that the Rush litigation could only properly proceed once there was full discovery of documentation. The litigation has been paused pending the outcome of the public inquiry. A public investigation into the Omagh bombing and its preventability, which is what the Rush civil action would have become, is not frivolous, nor vexatious. This establishment of the inquiry is evident of that. The truth about the preventability of the Omagh bombing is uncomfortable. The Rush family view this public inquiry as an important moment in history in trying to uncover the truth and providing some answers for all of the families. They ask you, Mr. Chairman, to now carry the baton they have tirelessly carried 4 years to help them find the answers they've been searching for. The terms of reference are not all encompassing, however, they are sufficiently wide to reflect the concerns of Lawrence Rush. No one knows, Mr. Chairman, where the evidence will lead you, and the Rush family hope that all avenues will be explored. The Rush family, alongside other families, have a lot of information which they have accumulated over the years and hope for maximum participation. May I say just at this stage, the issue raised by Hugh Southey moments ago about special advocates and direct questioning, we defer to the next hearing on the 20th and 22nd July. They ask for as much transparency in open hearings as possible. The Republic of Ireland, the Rush family requests that everyone who's been involved in any way should cooperate fully with the inquiry on both sides of the Irish border. The Rush family had hope that there may be a parallel inquiry in the Republic of Ireland, but that is not the case, and that is obviously supporting the others who have made that same proposition to you. They welcome the Memorandum of Understanding with the Republic and hope this is sufficiently robust to ensure transparency in the exchange of information across the two jurisdictions. There are clearly many important questions which must be answered by the Irish government relating to the lead up to, time and aftermath of the Omagh bombing. These are amplified because of the overlap of terrorist activity and involvement of identified individuals across both jurisdictions. The following assumptions can be made even at this preliminary stage. that in all probability some element of planning of the bomb was carried out in the Republic of Ireland, that in all probability some perpetrators came from or were involved with individuals from the Republic, that in all probability information which identifies and concerns the perpetrators still exists in the Republic of Ireland, that in all probability there will be information relating to the issues in the terms of reference in relation to the Omagh bombing, which is in the Republic, that in all probability there will be relevant witnesses in respect of the bombing who reside in the Republic. The Rush family say that it is therefore imperative that there is full cooperation on both sides of the border. There is a risk that if the commitments provided by the Irish government and other state authorities in the North of Ireland are not honoured, this could grind the inquiry process to a halt. The Rush family make a plea that this inquiry does not become a further endurance test of their strength and courage. Each of the bereaved families have suffered enough. In an affidavit on the 18th of May 2005, 20 years ago, Lawrence Rush said, "It's my honest belief that in particular, as a result of all the information contained in the police ombudsman report, with particular reference to the pre-warnings about an attack on Monday, the 15th of August 1998, that the murder of my wife may have been prevented by the defendants. There is significantly more information available now, which the Rush family say supports their belief that the Omagh bombing was preventable. The Rush family are embarking on this chapter of Omagh with positivity and hope. They, along with the other families, have demonstrated remarkable strength of courage. The Rush family hope that this public inquiry represents the beginning of the end of the story of the Omagh bombing. And if I may be permitted, just to add, it's a tiny postscript, but given what is going on globally at the moment, it is important to remember the words of the President of the United States on the first anniversary of the Good Friday Agreement in 1999. And I'm quoting from this very little, I just a little want to quote from this because of its significance in terms of the status of this inquiry and the important role this inquiry plays in the rule of law and adherence to a judicial process. And this is what he said: "As we approach the first anniversary of the Good Friday Agreement, we can all take heart at how far we've come in a year. The agreement has provided the basis for two traditions to work together, both in Northern Ireland and on the island as a whole. For the first time in 200 years," I paused, "I hope that the Republic will respond to what is being said here. Democratically endorsed by an emphatic majority of people in both the North and the South, it gives a unique opportunity for peace and reconciliation in which all the signatories can take pride. And of course, that includes the Republic. It has rightly been acknowledged as an example to the rest of the world how dialogue can bring an end to conflict. These are acute and singular resonance, these words, now, today, in the present circumstance, where the rule of law is being ignored and processes and institutions upholding it are being ignored. What is happening here with your inquiry is continuing exactly what was set out in 1998. And the President went on to reference Omagh in this statement in 1999. Despite the progress, Omagh demonstrated that the peace has not been a perfect peace. He goes on, but the response to Omagh showed that despite the pain, there is deep determination in both the North and the South that peace is the only path. And we say to you, sir, you're part of that path towards truth because, as has been said so many times, There can be no lasting peace without truth. Thank you.
Thank you, Mr. Mansfield. We hope that you might be able to join us in person at the next hearing of the inquiry.
Yes, I will be there.
Thank you very much. Mr. Greenie.
Sorry, I was about to ask Mr. Mansfield to turn off his camera and his microphone, but he's...
Yes, sorry. Straight away.
So that then concludes the opening statements of the core participants. Many important questions have been raised by the bereaved families and survivors over the course of the last 2 days. We expect that no one would expect the inquiry legal team to be in a position to answer all of those questions at this stage. But there are 2 issues upon which we do feel we can provide a degree of further clarification. First, in the course of our opening observations yesterday, we acknowledged the concerns of the bereaved families and survivors about missing documentation. And we made plain the rigorous approach that the inquiry intends to take to any claims that are made that relevant materials cannot be located. In his opening statement, Mr. Kane gave an example of a category of missing documentation. He referred to the fact that it was the inquiry which had identified the relevance of the agenda and briefing papers for and minutes of the security policy meetings. And he identified too that the inquiry had sought these materials from the Police Service of Northern Ireland. Mr. Kane, as we all heard, went on to express the serious concerns of those that he represents about the failure of PSNI to locate any such documents for the years 1997 and 1998. Those concerns, in our view, sir, are understandable, but there is more to the story. The bereaved families and survivors can be assured that, in accordance with the approach we set out yesterday, the inquiry legal team will not simply accept at face value that PSNI cannot locate these documents. Explanations have been sought, and those explanations will be tested. Furthermore, it's important to emphasise that the inquiry's search for these documents has not been limited to a request of PSNI. As Mr. Kane set out, the security policy meetings were attended not only by senior police officers, but also by a range of other senior figures involved in security policy within Northern Ireland. And that range of persons included the Permanent Secretary in the Northern Ireland office. As a result, at the same time as seeking the material relating to the security policy meetings from PSNI, the inquiry also sought that material from the Northern Ireland office. Initially, the Northern Ireland office asserted that it had destroyed those records. The inquiry pressed the NIO hard for an explanation of why those important records had been destroyed and in what circumstances, and the inquiry required further searches to be undertaken for that material. So the upshot is that on undertaking such further searches, the Northern Ireland office has now located most of the documents that PSNI was unable to locate. And the inquiry is actively taking steps to locate the balance. So we hope that this single, albeit small example, will provide reassurance to the bereaved families and survivors, and indeed the wider public, as to the rigour with which the inquiry will seek the documentation it requires for its work. So that is the first issue upon which we are able to offer some clarification. The second issue relates to concessions, a topic upon which Mr. Mansfield, of course, has just addressed you. Mr. Mansfield has noted that in our opening observations yesterday, we referred to the requirement that state court participants make concessions where they recognise failings have been made. Mr. Mansfield noted too that against that background, we said the following yesterday. Quotes, in their written opening statements, The state core participants have not made any such concessions. Today, indeed this afternoon, Mr Mansfield has highlighted that the inquiry's protocol on opening statements says this, quotes, "In the event there are mistakes or failings which a state core participant considers can only be acknowledged enclosed due to the risk to national security, an account of those failings must be provided in writing to the inquiry legal team in a closed environment at the same time as the open written opening statement." End quotes. In those circumstances, entirely understandably, the question that has been posed by Mr Mansfield, in effect, is this. Was our comment yesterday that the state core participants have not made concessions deliberately unequivocal? The answer is it was. The state core participants supplied their opening statements in open. Those opening statements contained, as all have observed, no concessions and gave reasons for that position. It is a fact that no closed opening statements were submitted. So, sir, where we reach is that no concessions have been made. That, sir, is all we propose to say at the end of Chapter 2 of the inquiry's work, save to thank those who have attended or who have viewed the proceedings online, and save to thank the legal representatives for the positive and cooperative way in which they have engaged with this process. And so we believe that finally you have something that you wish to say.
Thank you, Mr Greenie. I would wish to say that I'm grateful to all of the Council for setting out and delivering their respective opening statements. Each has contributed in a helpful and informative manner. Hearing the state core participants explain the processes which they're engaged in will help all of us to understand the challenges which some of them face in providing disclosure to the inquiry. I do not doubt that these challenges are significant. In the case of the Secretary of State for Northern Ireland, he, as a core participant, represents not just his own department, but all of the other departments across government who hold material that is of interest and value to the inquiry. So that adds to the complexities for the legal team he has instructed. It also raises issues concerning two matters in particular. First, the management of the requests from the inquiry. And second, the resourcing needed to comply with those requests. Regardless of the efforts now being made, such as were outlined by Ms. Fee in her opening statement, the fact remains that 2 years have already passed since the Secretary of State announced that there was to be an inquiry. At many times since that point, the progress towards setting up the inquiry and then of trying to move towards evidential hearings has appeared to be frustratingly slow. Difficulties over providing disclosure, of course, impact on the ability to schedule evidential hearings. Many of the complications which make that disclosure such a slow and difficult process are inherent in the task of trying to trace documents and information from so many years ago. Whilst all of us will understand the reality of those difficulties, some of those listening to what was said may have been thinking to themselves that if the various Secretaries of State and other ministers involved had not so staunchly set their face against a public inquiry over the very many years and very many times that such requests were made, the problems now being grappled with would not be so acute. Of course, I also recognise that the government departments with whom the inquiry liaises have many other demands placed upon them, and that is perhaps particularly the case for the Secretary of State of Northern Ireland. So I recognise that we are where we are in regard to the timing of the inquiry and the progress to date. I have one observation to make, though, in that regard. Having opposed the setting up of an inquiry so long, there is a plain duty on the Secretary of State and others in government to remedy that now by making available whatever resources are necessary to ensure that full disclosure can be swiftly made available. And I say that not just because of the passage of time. My experience to date has caused me to have some concerns. I have not been convinced that some of those with whom the inquiry has to depend upon to provide it with the materials it seeks have always been in a position properly to engage with the inquiry or to dedicate the necessary resources to those tasks. I therefore trust that after all that's been said over today and yesterday, that my remarks and concerns will be passed on to the relevant ministers and others who manage the responses to the inquiry's requests. Separately, it was, of course, most informative to hear from the family court participants and to learn of the areas which they are most interested in seeing the inquiry explore. For the most part, these areas of interest seem to be shared across the differently represented groups. And again, for the most part, the matters which the court participants wished to see being explored are reflective of what the inquiry legal team has in mind, as is foreshadowed in the provisional list of issues. Having had the benefit of listening to the submissions, I and the inquiry legal team will reflect further on everything that has been said. However, there's one point which I would like to revisit. As was acknowledged in the submissions presented by Mr. Southey, the terms of reference for the inquiry mean that there are limits to what it can consider. That is self-evidently correct. Some of what flows from that boundary to the inquiry's jurisdiction is set out in the list of issues. It is noted there that there are several issues which fall beyond an analysis of preventability. The first of those specified matters is an examination of, and I quote, the UK state's response to the 2 telephone calls made on 15 August 1998 to Ulster Television and the single call made to Samaritan Service, sometimes referred to as the warning calls. The attempts made to evacuate people from the location the bomb was believed to be in, and the emergency response to the Omagh bombing more generally, close quote. As is stated in the list of issues, an analysis of these matters is not within the inquiry's terms of reference. A further aspect of the value which emerged from the opening statements presented on behalf of the family court participants was to learn of the concerns which they harbour. One matter which emerged very plainly was the ability to obtain relevant documentation after so many years have passed. The family court participants have rightly drawn attention to the concerns which they hold over statements made by state bodies about apparent inability to locate relevant documents. The inquiry shares those concerns. What I would say is that while I recognise that the passage of time brings with it challenges, as Mr. Greene has emphasised, the inquiry will simply not accept statements that what appear to it to be important documents have been destroyed or cannot be found. As the families have pointed out, claims of this sort have bedevilled some previous inquiries. As it happens, I do not even need to look to experience in other inquiries to vouch the importance of assessing such claims with care. I have already seen for myself an example of how assertions that documents have been destroyed can turn out to be unreliable. Where claims are made that documents of importance have been destroyed or cannot be located, material providers can expect such assertions to be subjected to the most rigorous scrutiny. Accordingly, the inquiry will expect to hear detailed evidence as to the nature of the efforts made to locate any such documents and the processes around their storage and retention. And having done so, the inquiry will draw such inferences as seem appropriate in light of the nature and importance of the documents concerned, alongside the quality of any evidence given by way of explanation for their absence. Another area of concern which emerged clearly from the opening statements of the family court participants was that of cooperation between the inquiry and the authorities in the Republic of Ireland. These are understandable concerns, even if some are expressed in more trenchant language than others. I have no doubt that the more strongly worded and sceptical remarks passed concerning cooperation were formulated through the lens of long previous experience. But by way of contrast, I come to these proceedings unburdened by any previous experience of contact, negotiation, or communication with the authorities in the Republic of Ireland. Some may consider that an advantage, others a disadvantage. However, it allows me the luxury of an open mind. I therefore take the various assurances which have repeatedly been made by senior members of the Government of Ireland at face value, and I assume that they are made in good faith. That is the approach which I will continue to take unless and until I am given reason to think differently. So the inquiry will now adjourn until its next hearing, which will take place on Monday, 21st July.